Good evening and welcome to the regular meeting of the Madera City Council. Today is Wednesday, November 2nd, 2022. It is now 6 p.m. The council chambers will be open to the public. This meeting will also be available for public viewing and participation through Zoom. Members of the public may also observe the live stream meeting on the city's website at www.madera.gov/live. Members of the public may comment on agenda items at the meeting or remotely through an electronic meeting via phone by dialing 669-900-6833, enter ID 811-4179-2507, hashtag. Comments will also be accepted via email at citycouncilpubliccomment@madera.gov or by regular mail at 205 West 4th Street, Madera, California, 93637. Alicia, would you please call this, I call this meeting to order. Alicia, would you call the roll call?
Mayor Garcia?
Here.
Mayor Pro Tem Evans? Here. Councilmember Gallegos? Here. Councilmember Rodriguez?
Here.
Councilmember Montes?
Here.
Councilmember Mejia?
Here.
And Councilmember Villegas?
I'm here.
Thank you very much, Alicia. We will now move on to the invocation led by Pam Grewal, Madera Sikh Temple. Would you all please rise?
All right.
Thank you, everyone, for having me here again. It's an honor to be here, just like always, and just getting better at it. And I appreciate your patience, because that's what God is all about, is patience. That's what we need. It's what we have. In this room, I know for a fact that if you wouldn't have patience, you wouldn't be here, because we go above and beyond our families and to serve our community. Please put your heads down. Dear God, bless all these people that are in this room. They are serving you in many different ways. We don't have to be in church to serve you. We can serve you here in the city hall. They are serving every community member in the community. I ask of you, God, bless them with good health. Take care of them. Give them the courage to make right decisions for the greater good. I ask of you, God, keep us all in your spirit. Dear God, we're so thankful for everything we have. I know for a fact that every single one of us has a family, and we're serving you above and beyond. Please keep us within your prayers and keep us protected so we can keep protecting others that cannot protect themselves. Dear God, I ask of you to give the courage to Madera community to praise your name more. I ask of you, dear God, keep those in your prayers, the ones that are suffering from drugs. It's a big pandemic out there. Moms are suffering, brothers are suffering. We don't understand what's going in the world today. You keep us safe on the streets. You keep us safe wherever we're at, dear God. Fear has spread so high. We don't feel safe in our cars. We don't feel safe in our homes. We can't lock the doors to everything, God. The worst of all, God, right now, we're locking the doors to communication. That communication it connects us with you and each other. Please keep these doors open. That's what humans are all about. That's how we get to know each other. Dear God, I ask of you to protect every single person within the police departments, the sheriff's departments, the fire departments, and even the security. When they put on those uniforms, dear God, to protect us, please protect them. I ask of you, God, to give the courage to this panel that's sitting up high to represent the city of Madera and have me here to say your name. I appreciate them and I appreciate you, dear God. And I know You're within each one of us. We don't have to look down. We don't have to look to the sides or up high in the sky. You're within me. Thank you, God. Amen.
Amen.
Thank you, everyone.
Amen.
Thank you. Would you please remain standing for the Pledge of Allegiance led tonight by Councilmember Jose Rodriguez.
To the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
We will now move on to the approval of the agenda. I will ask my colleagues if there are any questions or changes to the agenda. Seeing none, I'll ask for a motion.
Mayor, move to approve the agenda as presented.
Second.
Motion to approve the agenda by Councilmember Steve Montes, second by Councilmember Cici Gallegos. Alicia, would you call the roll, please?
Councilmember Gallegos?
Yes.
Councilmember Rodriguez?
Yes.
Councilmember Montes?
Yes.
Mayor Pro Tem Evans?
Yes.
Councilmember Mejia?
Yes.
Councilmember Villegas?
Yes.
And Mayor Garcia?
Yes.
Motion passes unanimously.
Thank you very much, Alicia. There are no written communications. Well, we're going to go into public comment, excuse me. The first 15 minutes of the meeting are reserved for members of the public to address the council on items which are within the subject matter jurisdiction of the council. Speakers shall be limited to 3 minutes. Speakers will be asked but are not required to identify themselves and state the subject of their comments. If the subject is an item on the agenda, the mayor has the option of asking the speaker to hold a comment until that item is called. Comments on items listed as a public hearing on the agenda should be held until the hearing is opened. The council is prohibited by law from taking any action on matters discussed that are not on the agenda, and no adverse conclusion should be drawn if the council does not respond to public comment at this time. Is there any public comments, Alicia?
I do have one written public comment, Mayor, was received today from Kirk Atamian. I want to address all the trucks parked on Highway 145 between Avenue 12 and a half and 13. First, we started with a few trucks and next people turned it into a car lot on the corner. Now it becomes a homeless camp. Caltrans owns part of the property and my family the rest. By allowing these people to park and live there, they dump human waste where they live, plus truck tires are piling up. I posted signs, but they are all gone the next day. I also contacted Caltrans and the response was they don't ask people to move. The one trailer with advertisements has been there for 3 years. There are RV people who live in and do auto repair. I want you to think about it. If the same RV was parked in a parking lot outside, how would you handle it? That's how all properties should be handled. Madera cannot let it get out of control like other cities have. I have attached pictures for everything. And I can share the email with council. That way you all have copies of the photos as well.
Thank you very much, Alicia. Are there any further public comments in written form?
No other public comment, Mayor, no.
And no one on Zoom or on the phone?
Correct.
Thank you, Mark. Anyone here in the public wishing to speak on anything? Thank you very much. Then we will close public comment. There are no written communications. We will now move on to presentations. We do have a proclamation recognizing November as Lung Cancer Awareness Month. Unfortunately, the folks who were supposed to receive this will not be able to attend. But in essence, we are aware that lung cancer is a serious issue in our communities, our loved ones, and we wanted to share with them that we do recognize this, and we have developed a proclamation to that end. We will now have a presentation by the California Low Cost Auto Insurance, presentation by Richie Sarivong of the California Department of Insurance.
Good evening, Mayor. Thank you again for having me present this evening to the City of Madera. My name is Richie Sayavong. I'm with the California Department of Insurance. I am the outreach analyst for the Central Valley, as well as the Central Coast and parts of San Bernardino. So a quick overview about the California Department of Insurance. So California is the largest marketplace in the United States for insurance.
It's not showing on our Zoom
Okay.
screen. Sorry.
Technical difficulties. But as I mentioned, California is the largest marketplace in the United States for insurance. Collectively, Californians pay $340 billion a year in insurance premiums. So we have to have an agency that does oversee that and manage that to make sure that all insurance companies in the state of California are playing fairly. So a quick overview about the California Low Cost Auto Insurance Program. It's also known as CLCA. It's been passed by the legislature since 1999. And been active since 2000. So it is a program that is sponsored by the state. It is no way in use of any taxpayer funding. It is simply a pool of all the auto insurance companies here doing business in California, providing this liability insurance to Californians. So it is targeted to low to moderate income Californians, regardless of immigration status. And the goal, of course, is to decrease the number of uninsured drivers. As you know, the law in California is that every driver on the road has to have at least proof of liability insurance to drive safely on the road. So how do you qualify? It is quite very simple. So you could either have a California driver's license or an AB60. The vehicle that you own has to have a value of less than $25,000 and cannot be financed through a loan. You have to meet income guidelines, which is something I will go over shortly. And then you have to at least be 16 years old. So the little asterisk there saying that you can't have a bad driving record for the past 3 years, that means you can't have an accident with bodily injury or more than 1 point on your driving record. So quick look at how much rates would be across the state. So Madera is in the first tier. So the lowest that anybody on this program would pay base-wise is $244 a year, or the highest would be $488 a year, which pretty much breaks down to about $20 a month. So what do you need to apply? Your AB60 or driver's license, valid registration, your proof of income, and a down payment of 20% of the annual premium. So the proof of income, this is what I'll go over. So you can either provide a paycheck, a W-2, a 1099, SSI statement, etc. What's really great about this program as well is that those that do qualify for CalFresh, Medi-Cal, or any other county state programs that are tested by the means of income do qualify for this program as well. There is a complete list available on mylowcostauto.com. And you're wondering, how do I apply? So we have a website specifically set up for this. It's called mylowcostauto.com. You do take the eligibility questionnaire. It's about 7 questions. The whole application process is online. And once you do complete that, an agent will reach out to you regarding all the other information they need. And then our chat is available in English and Spanish from Monday through Friday from 8 to 4. And our contact number is 866-602-8861. And if you happen to have questions about the CLCA program, visit our website, and you can also always give us a call. We do promise to get you a live agent within 2 minutes. And any questions or problems with your insurance company, give us a call because we're here to assist you with that. The department is here to protect you against fraud from all insurance companies. We're making sure that you're paying fairly into the marketplace and they're not charging you outrageously high rates. And the consumer hotline is right here. It's 800-927-4357. And this concludes my presentation. Council, I'll take any questions if you have any.
Thank you very much. 2 minutes. That was, well, you said that you would get somebody on the line in 2 minutes. I thought, well, that's pretty amazing.
Oh, yes.
And also your presentation was pretty short too, but you got a lot of information in there. So we appreciate that.
Thank you.
As far as my colleagues, do you guys have, does anyone have any questions? Mr. Rodriguez.
Quick question, Richie, on the, you mentioned that the eligibility, the person must not be in a injury that resulted in bodily injury.
Correct.
Now, if that person's not at fault, does that also go against that person?
So as long as the person is not at fault, it's on their record, just as long as they weren't the one that caused the accident, that caused the injury, they will qualify for this program.
Okay. And you'll provide that information, I'm assuming we have that information with their clerk?
Oh, yes, I can send this all over. I can provide brochures all sent over, spread through the community. And that's another thing too. If there's ever anything within the community of Madera that would see fit for my department, as well as sharing this program, by all means, feel free to reach out to me.
Yeah, no, great. I don't think a lot of folks really know about this low-cost auto insurance. I think they're required to have insurance. I don't know that they know this avenue. So thank you. Appreciate your presentation.
No problem, sir.
Mayor Pro Tem Evans.
Yes, so as far as your program is concerned, with seniors, with them having Social Security and the Medicare and all of that, they don't have to take any type of physical or anything of that nature?
That's correct.
Okay, very good. No accidents, no physical. Okay, thank you.
Councilmember Mejia.
Yes, thank you, Richie, for this very brief and helpful information. I would like to know if you have any marketing materials and that we can share, especially in Spanish.
Oh, yes, definitely. We can definitely send over brochures in Spanish, and we are working with producers in developing a more commercialized advertisement of the program itself.
Okay.
Richie, do you have any cards?
I have my business card on me, but I can send this over to you as well.
Okay, thank you.
Thank you.
Can you qualify me on the spot?
$20 a
Well,
month.
you must have a nice low income. Yeah. Well, I want to thank you very much for your presentation. It's been very informative, and I'm sure that the website will give us a lot of information. And of course, you'll be sharing more of your stuff with our city clerk, Alicia.
Oh, yes. Yes, definitely. My contact information might say I'm from LA. That's my home office, but I born and raised in Fresno, so I'm Valley kid.
All right.
So yes,
Well, thank you very much.
thank you.
So there are no introductions today. We will now move on to item A, workshop, A1, Brown Act workshop and future governance presentation. I believe, Hilda, you have this item?
Good evening, Mayor, City Council, members of the public and staff. This evening, I have the pleasure of presenting to you a Brown Act training session. This is the first of a number of sessions that will be presented to you per your request to provide some governance sessions for you. Some of them will be more back and forth where you would be much more of a participant. This one's going to be more of a strict training session. There's a lot of law in this one. And I do ask that you hold off your questions until the end, because what happens with these, the way these are prepared is that often the questions that you have will be addressed as we move forward. And but I do want you to ask questions. because that's really important for you to ask questions. I assume all of you have previously attended a Brown Act as part of your AB 1234 training.
Yes.
Right. So you have a basic understanding. This digs in a little deeper. And one of the things we're doing is this will be the first one. What I want to do, instead of having an AB 1234 training where everything is rushed, you have 10 minutes of conflicts of interest, 5 minutes of due process, 10 minutes of public records, and everything is kind of rushed. It's good and it meets the legal requirements, but sometimes you don't get the full understanding. So as we proceed, the city clerk will keep a record of your attendance here. And then when we do all the others, ultimately, you will be obtaining an AB 1234 certificate. Of course, our sessions will go way beyond what AB 1234 requires. So after this session on the Brown Act, the city manager and I are here to answer any questions in general about the upcoming sessions or further direction that you may want to provide concerning the future sessions. All of you received a hard copy of the PowerPoint presentation. I will note that after I looked at it and after I sent it on, I noticed 2 or 3 little typos and just corrections that need to be done. So I will send you a newer version after tonight's meeting so that you have the correct one. And so we begin. Let's see. So what is the policy behind the Brown Act is captured in language in the legislation itself. And it's very firm and it's very direct. It says the people in delegating authority do not give their public servants the right to decide what is good for the people to know and what is not good for them to know. The people insist on remaining informed so that they may retain control over the instruments that they have created. And that's a whole policy. And so that gets us to what the basic description for the Brown Act, which is open and public. Whenever you hear about the Brown Act, the 2 words that are very key are open and public. In that regard, the League of Cities publishes this booklet. It's called Open and Public. I was one of the authors for Open and Public 4, but this is Open and Public 5, and now there's a group working on Open and Public 6. And you can download it. It's real good. Sometimes you have questions that you want to look up, and it's really helpful to have this. So it's something that I always recommend that governing boards have available and put in their binders. I think in your city council binder, it's helpful to have a number of documents. And as we go through the training sessions, we'll let you know what all those documents should be so that you have access to everything, your code of conduct, your conflict of interest code, the Brown Act, Public Records Act, et cetera, et cetera. And you probably have noticed already that I have a cold. So I'm going to be taking breaks to drink water. So who is governed by the Brown Act? You know that you are, and you are the city council for the city of Madera, and that is why you are. The term that's used in the Brown Act is legislative body, and that's to capture not just city councils, but boards of supervisors, board of directors for different special districts, board of trustees for school boards, et cetera. It also applies to your boards or commissions that you have created. And also, if you were to have a standing committee, you do not, but if you were to decide to have a standing committee of the city council, then that would also be subject to the Brown Act. So what is a meeting? Because that's what's key, right? A meeting, again, I'm quoting the language, is any gathering of a majority of the members of a legislative body at the same time and location, including teleconference location, to hear, discuss, deliberate, or take action on any item that is within the subject matter jurisdiction of the legislative body. So the underlined words are very important because we're going to get into something called serial meetings. So a lot of times what people thought is there is language here that says at the same time and location, but at the end of the day, those words are not as important as the ones that I have underlined for you. Majority of the council members, which in your case would be 4, to hear, discuss, and deliberate or take action. So serial meetings are prohibited. And what they are is a use of a series of communications of any kind, whether they're direct or indirect, and whether they're through intermediaries to discuss, deliberate, or take action, again, on any matter that is within the subject matter jurisdiction of the city council. And such communications are considered serial meetings and would be in violation of the Brown Act. And so 2 examples that are given, and I apologize, I noted after I sent it, this is one of them. The examples I used were for a 5-member board or 5-member council, which are more traditional. You have 7. So in the example I have for a chain, it's member A speaks with member B, member B speaks with member C on the same subject. And that could be considered a serial meeting. In your case, with a body of 7, it would be 4 people. And that's similar, you have the hub and spoke, where you have member A speaks with member B, and then member A later speaks to member C, and then member A, in your case, would speak to member D on the same subject, again, getting to a quorum. And internet communications and social media are a big issue, as you know, in governance, in government, in politics, everything, our daily lives. And so even when you're blogging or you're posting or you're tweeting or liking or commenting, always consider the Brown Act, because serial meeting rules that apply to traditional communications and email apply to other digital and social media online conduct. So I advised you at the end of last year, I advised you that effective in January of 2021, we had a new law concerning internet communications. So simply posting general city information without personal opinion or comment online is fine. But once you start with those little emojis at the bottom of this screen, a thumbs up or a heart because I love this, or a frown, or just crying about something, that could be considered action taken and is not permissible. These are harsh rules, huh? And they're interesting because it's, you know, in everyday life, that's what people do all day long with their regular daily life. And then you really have to change what you do and your conduct when you're dealing with city matters. And so the old law used the term technological devices. In original, of course, we had telephones. Now we have email, we have IM, we have texting, blogs, social media, et cetera. And so those technological devices can create a virtual serial meeting, which again would be impermissible. And city attorneys really don't like email. And you know, from whenever I send you attorney-client communications, I always have in bold lines, and you probably get tired of seeing it, but I say attorney-client, privileged and confidential communication. Please do not forward, please do not share, please do not reply to all. And the reason for that, again, is because it can create a virtual serial meeting. And the Attorney General, he was asked back in 2001, and that whether it was okay if the item was posted on the website, and the Attorney General said, no, it's not okay. And so there are at least 3 problem email buttons that we encounter. The send, as I noted, do not send whatever I send you or whatever is confidential or whatever is private in other ways that the manager may send you concerning, say, a personnel matter. Do not hit reply to all and do not forward. And the thing is that what starts out as legal under the Brown Act then can turn into something that's not permissible. So somebody can say, I think we should do something at our next meeting. I think we should adopt a particular program and approve a particular program. That's fine if one person says that. but it does become illegal when it is replied to by a majority and the majority says, I agree, or the reply to all is good idea, again, if you have a majority, or concur. So often what another method that's used is the BCC method. I don't think the city manager uses that methodology. So what is not a meeting? If all these things are meetings, and what can you do? Well, obviously individual contacts. If you speak with one council member or even two, that's fine. That is not a meeting. Or attendance at conferences, which you often do, and other gatherings, such as the League of Cities, which you attend in September. Generally, there's a majority, and that's okay as long as members do not discuss among themselves business of a specific nature under the city's jurisdiction. And that's a proviso. And so the other one is attendance at social or ceremonial events. Again, the same proviso, highlighted in yellow. Meetings with other agencies. Again, the proviso, highlighted in yellow. And one of the things to note here is that with a lot of things we do, like with conflicts of interest, for example, we say it's not a conflict of interest, but you may want to consider not participating anyway. And the same thing here. It may not be a meeting because you're at a gathering and all that, but if people see that four of you are sitting together at all these types of gatherings all the time, at some point, somebody's going to say, well, what do you think about that agenda item that's going to be on in next month? Or what do you think about what happened? Should we do? And again, inadvertently, things happen. And so just be careful. So there are sometimes what are called collective briefings in the old days. Some in the very old days, remember, I've been doing this for over 40 years. So in the old days, city managers would literally sit down with all the council the day before a council meeting and go over everything. And that's not permissive anymore. However, there can be collective briefings of 2 or 3 of you at a time. And that's permissible, but you still have to be somewhat careful that it doesn't turn into something else. And so I recommend that these meetings where the city managers briefing you on items, that they be what I call unidirectional or one directional. It's the city manager providing information about items on the agenda and some of the issues. That's fine. And you may ask questions, but just be careful not to start, talking about, well, what does, council member so-and-so think about it? And then all of a sudden the city manager, should not be telling you what other council members think. And you should also be careful to start asking about that. So just don't ask about other members' views in these meetings. The purpose is to provide you more detailed information because it is difficult. Some of these items that you discuss in your meetings are complex. They're detailed. There's a lot to them, and it's a lot easier for you to be able to go into your city manager's office and get more information and an explanation. And there are times when you would prefer to just ask in public, and because you want also your constituents to understand what is being provided. So again, informal gatherings where business of the agencies discussed could be a meeting. Advisory committees created by the city council. And again, we already talked about standing committees. And meeting locations, that's highlighted right there on this map. You can have your meetings within the city of Madera, unless it qualifies for a special exemption, sometimes where you have to go visit say you're building a new water treatment plant and there's a need to go visit. There's some very limited exceptions that we could get into at another time, but generally it's within the city of Madera. Again, when I started working on as a deputy city attorney, the city councils used to go to Monterey and then Southern California for their retreats, because they used to have retreats and they could have them anywhere they wanted, and they were not open to the public. All that has changed. So we get to virtual meetings. And we've learned a lot in the last couple of years since COVID about virtual meetings. First, let's go through the traditional rules where all the agendas have to include all the teleconference locations in the notice and agenda of the meeting. The teleconference location must be accessible to the public, but at least a quorum must be within the city boundaries. And the agenda has to provide an opportunity for members of the public to address the council at each teleconference location. Can that be done? Yes, it can, but it is quite onerous. It is difficult. And I've had situations where, years and years ago, where council members got sick and they wanted to have, participate under these rules, and they did. And then all of a sudden people got interested and they said, hey, I'm not going to go to the council chambers. I'm going to go to Councilmember Brown's house and attend the meeting there. And then you have to have microphones and everything because they have to be able to speak. So after a couple of sessions, that council member said, I'm just going to have to be absent from 2 or 3 more meetings because until I get over my injury from my accident. So then we get to AB 361, which is what you have been living on for last couple of years, and what most boards and commissions in California have been doing as well. And the rules are much more relaxed. You can have your meetings via teleconference, and at one point, all of you could be on video. The thing is, the notice and agenda still has to be posted, and it must identify the opportunity for all persons to participate via call or attend online. And one of the issues there that did come up for some of my clients, I don't remember if it came up here at any one point, but for some of my clients, the meeting had to just be shut off because there were technical problems and we could not resume after 5 or 10 minutes, and we just had to terminate the meeting. And that process has to be verified every 30 days. Now you get a consent agenda item that says that every 30 days that you want to go ahead and continue with this. Although this law is not set to expire soon, in my view, I think it's going to be very difficult, if not impossible, for you to continue using this process past February. And February is when the Governor Newsom has indicated that he will be withdrawing and calling off the declaration of statewide emergency. And the reason for that is because with AB 361, there's a resolution that probably, since it's been on consent, people forget, but it continues to have findings of all the need and for people to stay apart and the health issues, et cetera. So I think it's going to be very difficult unless, God forbid, we were to get into another real serious problem. But I don't foresee that, and I don't foresee you being able to use AB 361 beyond February. So what do we get? We get a new law effective in January, this coming January, but it is, you think the traditional rules are onerous. This is very onerous, but it is another way to be able to have virtual meetings. It's effective in January, as I noted, and you have to have emergency circumstances or just cause. And I was trying to give you a flavor of what the emergencies are. I mean, you have to, the just cause is very, very serious. The member must notify the council in this case at the earliest opportunity. including at the start of the meeting, by the way, which is helpful because if something were to happen and you needed to just pop in the meeting, it doesn't have to be posted on the agenda or anything. And you could do it as early as at the beginning of the meeting. And we'll have to talk through if something were to come up like that on what the process would be. But including at the beginning of the meeting, and then you would have to explain what the circumstances are, such as childcare or caregiving of a child, parent, grandparent, grandchild, sibling, spouse, or domestic partner that requires them to participate remotely, a contagious disease, a need related to a physical or mental disability, and travel while on business of the council or another state or local agency. Those are just cause reasons. An emergency, they really don't really get into a lot of, it's more a physical or family medical emergency that prevents a member from attending. And so at the beginning, you would say, I call in, I want to participate. Is that okay, council? And we'll have to get through the process. But it is kind of onerous. And what I'm not sure I understand is the whole thing of having to reveal medical conditions and how far that goes. I would think that it should be a very general, more of an honest system where you say, I have a medical condition, I'm not able to attend, or I have something that's contagious, I'm not able to attend. But again, it is there. And again, that this is one of the corrections. It should be 20%. 2 meetings is for smaller, councils that meet like less than 10 times a year, but it's for 20% of the meetings you can only attend 20% of the meetings in a calendar year via this method. And that's one of the corrections I'll make. So what about the public? What are their rights in the meetings? And there, as you know, there are meetings when you will have a full house in the chambers and a full house online. And it really varies, I think, from topic to topic, from meeting to meeting, as far as what that goes. I have some councils where during COVID, there were always 30 or 40 people online and 20 or 30 who wanted to speak on items. So, and there's others where nobody ever showed up. And there's some where it's sort of sometimes, depending on the issue, people do come in. And so in regular meetings, as you know, there must be a time set aside to comment on any items that are not on the agenda. And so the members members of the public can speak on any item that's on the agenda for action. That's their right on every single item if they want. Thankfully, you don't have somebody like that in Madera, but sometimes some cities do. And then you can have the section where it's for something that's not on the agenda. And I think that's something we're going to clarify even more when we do the rules of council procedures that we're coming up, which will come up next. And so the public may criticize the city and city officials. They have a right to criticize that you're not paying attention to certain streets or certain areas of the city, or that your land use rules are too strict, or that your land use rules are too liberal. So they can criticize you and they can criticize the city. And this is basic, but you can't require people to register or to identify themselves. I think early on when I became city attorney, I advised you can't require people to state their name. You can request them. So we say, I request that you state your name and address for the record. And then they say no, and they can just go on and speak. That's their right. And wouldn't it be nice if you could charge fees for them to attempt to come watch you? You can't do that either. So there's another new law. And this law really doesn't change how I have advised my clients and what I would have in the rules of procedure that will be coming up, except that now I think because there's been so many problems in many cities where where boards and councils just can't even conduct business because it just becomes so disruptive. So this new law includes language of what constitutes disrupting behavior, and it's engaging in behavior during a meeting that actually disrupts, disturbs, impedes, or renders infeasible the orderly conduct of the meeting, and includes, but not limited to, failure to comply with your reasonable regulations, which we will be preparing for you for our rules of procedure. And for these, you have to give prior warning. But if somebody's, it also means engaging in behavior that constitutes the use of force or threat of force. And for that, you don't need to have a prior warning. So somebody's just, just being disruptive and just being very, very loud. And the mayor would then say, "Excuse me, ma'am, at the back of the chambers, would you please stop clapping so loud or yelling or whatever the person is doing?" And it is very important to provide a warning. I had a situation, I had a case a few years ago where a lady would come and criticize the mayor every single meeting. And the mayor was just very, very upset. And she spoke to the city attorney, and she told the city attorney, pretty much ordered the city attorney that she wanted that person out, that she was tired of it. And so the next time the lady came to the dais and started talking, before she even said anything, the mayor said, "City attorney," and the city attorney spoke up and just directed the police officer to come escort her out. Lawsuit, lawsuit, lawsuit. So there was a lawsuit, and as a result, it was resolved. I helped them prepare these rules. That's why I'm familiar with them on the warnings and all that. And the other thing we did was, because they used to have these slips where people would have to note whether they were going to speak or not. And again, on those also said, "You are requested to give your name." Otherwise, it would be like a number and to see who's next on speaking. Because you don't get that too much, but there's situations at Soroyan Theater or Selland where I've been advising the council where you have, 50, 60, 70 people talking, and there has to be some order, and you start giving people numbers and things like that, or you have to start having them line up. Or you start letting them say, "Okay, we're going to have 10 people speak for, and then 10 people against, and then continue on that way." So again, for really bad conduct, where somebody's really engaging in horrible conduct, then there's no requirement for a warning. And often what's helped for me when I advise councils is when sometimes it helps to just have the city council take a break and say, "Mayor, would you like to call a recess?" And the mayor will generally call a recess, and that also helps. That happens too when there's a little bit of a friction going on among the council once in a while, not very often, but once in a while it helps to just say, "Let's take a 5-minute recess." So as far as responding to the public, it's difficult because people show up and they have questions and they want you to answer right away. And so that's why we have the language that we added to your agenda that says we're not able to take action on any items on the agenda. We may be able to provide a brief response or refer it to staff, or we may put it on a future agenda. So you listen, and then at the end of the meeting or at a future meeting, you may decide to put something on the agenda concerning something that a particular person who came to speak with you presented. And as far as votes, everything is public, no secret ballots. Sometimes it's hard. You guys are used to it. Some of the smaller communities early on, when I was representing some of the tiny cities, it's hard because, say there's a vacancy on the council and they went up and there's 2 or 3 people, everybody knows everybody. And can't we have a secret ballot, or can we have a closed session? So the answer is no, you don't have secret ballots under the Brown Act. And as far as meetings, they can be broadcast, audio recorded or video recorded by anybody, as long as that person is not disrupting the meeting. And so it's helpful if people who want to do any taping or broadcasting contact the city clerk before then. And again, those are kinds of things that we may want to put on our future agendas. That way people know and not just show up with all their equipment. Agendas for regular meetings. For regular meetings, your agendas have to be posted at least 72 hours in advance. And your city pretty much meets that because they're posted on Friday, sometimes as early as Thursday. Some cities have very strict rules and say even like 10 days before. But per the Brown Act, it's 72 hours. And your agendas are also important when I review your staff's staff reports and their recommendations. I try to be helpful in ensuring that the agenda says what they want to do. Because sometimes what I've seen is that I read the staff report and it doesn't in any way sound the same way as a recommendation. And then that is different from the agenda language. So trying to make sure that the language is reconciled. And sometimes what happens too is that staff will present their agenda language to the city clerk, and then they send it to the documents to me for review, and I recommend that edits be made. So the staff report will be correct, but then the agenda does not get reconciled. And so it's really important for staff to reconcile any edits with a final agenda, because the city clerk doesn't know that I've been dealing with, let's see who's on the line, Gary or Keith or Kingsley on different items, and that things change. And so we have to have a general description for each item that's going to be discussed or where action is going to be taken. And it should be presented in a way so that people know what it's about. And they have not too detailed that it prevents you from acting. Because sometimes if you word it too long and in too much detail, it can prevent you from deviating in any way. Because sometimes, as you know, you decide to change things a little bit when action is taken on something. So there's a bit of an art and a balance there as far as how agenda items are prepared so that they allow staff to present to you. They provide information to the public, and they give you some flexibility to take action in a different way if possible, if necessary. And then for special meetings, it's a bit different. Pretty generally, the rules are the same, but it's only 24 hours instead of 72 hours. And the same kind of information needs to be included. The big difference is that for special meetings is that you don't have what I call the generic public forum where they can talk about anything that's not on the agenda. For special meetings, you only need to put on, you only have to give members of the public the right to speak on agenda items. And that's another thing that we sort of changed as I came on, because, special meetings are for a special purpose. And the regular meetings is to talk about anything. And so the special meetings are devoted just to the items that require action or a workshop about a particular subject. We talked about this, just kind of being careful. One of the big, there was case law before, and now it's been underscored that if there's anything concerning CEQA, that language also needs to be on the agenda. So we need to be extra careful that the notice of exemption, the categorical exemption, the negative declaration, the mitigated negative declaration, whatever it is, that the agenda says that you're approving that, because we have a more recent case than the old case that I used to cite from LA. And one of the things too is sometimes if you have a resolution or if you have an ordinance, just use that in your recommendation. That way the wording is the same and you don't worry about changing it or making it unclear. So what happens if an item's not on the agenda? It can be added on the agenda, but it's very limited. It has to be something that came to the city's attention after the agenda was posted. And not something that somebody forgot or something that, well, let's go ahead and add it. That way we have to do it next time. No, it has to be something that came here to your attention after it was posted and that there's an immediate need to take action. And generally, if it may not meet that requirement, but generally you could have a special meeting for something like that if you really want to have it before the next regular meeting. Agendas must be posted online. This is not that new, but one of the newer provisions in the Brown Act that all your agendas have to be posted online on the city's homepage. And there's some general technical requirements that I'm going to confirm with your IT people. And there is, under the general Brown Act, not AB 361, there are provisions that if for some reason during that 72-hour period, your website went down and you can establish that happened and that as soon as you knew about it, that efforts were undertaken to take care of the problem, then there's an attorney general opinion that sanctions that. So there's something called sharing documents with the council after the council agenda is posted. Sometimes there are issues or reports where they're complex or the staff still doesn't have all the information. And so the agenda goes out. The agenda has the subject matter and the recommendation. So it meets the agenda requirement, but the item, the staff report itself, the documents, whether it's a resolution, ordinance, an agreement, they're not part of the agenda packet. And so the city staff wants to share those with the council before the meeting because generally councils tell staff they want items before the meeting, not during the meeting. And so there is a provision in the Brown Act that if staff does that and sends you anything less than 72 hours before, they must be available at a specific location. And the location needs to be on the website, on the agenda itself. For example, any writings within 72 hours that are sent to the council will be available at City Hall or at the public library, etc. And I've always also said that it needs to be posted online immediately at the same time. And there's a recent case called Sierra Watch where there was something from the Planning Commission recommendation on an agreement to the City Council, and the agenda went out on a Friday. And they were working on it, and they ended up changing the agreement, and they did post it online, but the physical location was at City Hall, and City Hall was, or the county was a county building, and the county building is closed on Sundays, right? So the court ruled against the county and said that they have violated the Brown Act because they had not provided actual notice. And they said the phrase "made available" means made actually available. So that's really important to note. And so one of the things that there's an old AG opinion that per my request from many years ago, that for agendas, it's easy because you can just post them on Windows and everything. But if you have like a 30, 40 page document, that's very difficult. So as a result of that, I guess somebody said, can we have a little bit of relief on that? So there's this another new law that becomes effective on January, and it's AB 2647. And again, it says that the initial staff and recommendation have to be made at least 72 hours before the meeting. And the writing is posted on the city website, has to be posted in a position that makes it clear that it's about an upcoming agenda item. And so in those cases, the court said 24 hours before the meeting, they have to post it, not during the weekend. So you have a meeting on Tuesdays, you post it on Monday, that would work. So those are all these little new things that I'll be working with Alicia on. Lots of fun, Alicia. So now we get to closed sessions, and closed sessions are one of the very rare opportunities that you can meet with each other, with key staff, not with just anybody, not with all staff, and with your attorney, depending on the situation. So there's very specific topics that are outlined in the Brown Act for you to be able to go into closed session. And again, the agenda has to notice that as well. Before agendas in the old days, you'd be in a meeting, council meeting, and then the council would say, I think we should go into the old terminology was, I think we should go into executive session. And the city council, the city manager, city attorney would leave. Nobody knew what it was about. It didn't matter how long, but they could do that. So now we have this. It says, no, you have to put on the agenda what it's about. And it can only be about certain reasons, for certain purposes. And there's even some what they call safe harbor language on the language that's used in your agenda. And so the language that we use mirrors the safe harbor language in the government code part of the Brown Act. As you know, prior to each closed session, the body must verbally announce the closed session. And one of the things that just to remember and just to remind ourselves on is when we announce a closed session, to ask, is there anybody on Zoom or members of the public who wish to address the council before we go into closed session? And so that needs to, I think it used to be put on the agenda. Somehow it got cut off, but we need to put that back on. Just, it helps to have it on there. And then, as you know, if there's action taken, then the requirement is that you report it out, and no matter how late, right? That there's a reporting out, and action has to be final action. It's not, because during the course of negotiations, say for real property, you're negotiating whether to sell or buy property, there may be direction to your negotiators to do something or not do something, but that's not action. Action is when it's a final deal, or in litigation, when you say, these are the terms that we will agree to settle if all these terms are in there. And those are usually just bullet points. Now, if you have the agreement in closed session and you say, yeah, we agree, that's what we want and we approve it, then you have to announce it. And when announcements are made, it's not just saying the council approved this or disapproved that or rejected a claim, but you have to give the vote as well. And we've been doing that here. So some of the common closed session are for personnel issues, but for personnel issues, it's for personnel matters where you have direct authority to hire, fire, not just for any other personnel matter. So you would have the authority over the city manager and the city clerk, but not over the city engineer, public works director, et cetera. There's language for public security that came up after 9/11, where language was added for governing boards to be able to meet in closed session concerning security. We had a couple of sessions under that category when COVID first came up, if you recall, in the early days. And then pending litigation, so that you can meet and talk to your attorney. Labor negotiations, as we mentioned, real property. And so those are the kinds of things that you can meet on regarding in a closed session. And disclosure of closed sessions is information is prohibited. You can't say, somebody can say, say you're trying to decide whether to file a lawsuit and the announcement is made, and then somebody says, yeah, I voted against that. They know you voted against it. Yeah, I voted against it. That's not a disclosure because that's already public information. But say somebody, the city's trying to settle with somebody, and then one of you goes and meets with that person for coffee, because you always have coffee with that person on Wednesday mornings. And you say, well, I can't tell you the details, but they're going to start really low. That would be divulging confidential information. So that's prohibited. And violations, and members of the public can bring actions to stop you from violating the Brown Act. And it's not just closed sessions, stop having serial meetings, require you to make sure that your agendas are correct. All these rules that we've gone over, they could be prevented or stopped by court order. And also the district attorney can bring an action, and they can get court costs and attorney's fees. And there's also criminal prosecution for a person who willfully violates the Brown Act. And that may be a tough one, but it is what the law says. It would be a tough one to prove because of the way the language is worded. So now it's your turn to ask questions or make comments about the Brown Act, and then we'll go on to some of your other sessions. Thank you.
Safe harbor. What's the definition of that? Because you mentioned it, but you didn't say what it
The safe harbor is the language. For example, there's a whole section in the code that talks about safe harbor. And what that means is if you want to have a closed session and you want to have it regarding real property negotiations, this is the way you have to word it. And it'll tell you this Brown Act language gives you the specific language. For example, conference with real property negotiators pursuant to Government Code 54956.8, property, the street address, APN number, agency negotiators, the names of the negotiators on both sides, the negotiating, under negotiation, price, terms, payment, or both. That language, if you use that language, then it's okay. And there's language like that for existing litigation, anticipated litigation, public employee dismissal, performance evaluations of public employees. So that's what safe harbor means.
Thank you.
Any other questions?
My colleagues, Mr. Montes.
Yeah, just real quick. Very good information. You actually answered one of them. But I still kind of sanctions. So for the remedies and sanctions of the violation, is that something? I mean, it's not automatic, obviously, right? Somebody has to be paying attention. What is usually the trigger for something like that to happen?
Well, generally it would, there have been situations and there's an opportunity to cure. For example, if somebody says that you didn't post the agenda the right way, or you didn't have the language the right way, or for enough time, they have to tell you what the challenge is. And then the city has an opportunity to cure it. And so the city basically there's different ways you could say, oh, we did make a mistake. We only published it for 71 hours instead of 72 hours, something like that. So we are curing it and reissuing the agenda and ratifying our decision. And there are situations where I've advised, we don't agree with them, but we don't want litigation. Let's just go ahead and say that even though we agree that we're going to go ahead and put it on the agenda again and have another public meeting concerning the public matter. Something that's really, somebody's engaging in lots of serial meetings or divulging confidential information. First of all, things like that are difficult to prove. And so there's different ways to approach it. You can just ask your colleagues to just a friendly reminder or, not to be divulging information. somebody apparently said this or that. So let's be careful about that. I mean, if it starts getting really, really egregious, a member of the public can go to the DA, or one of you could go to the DA. Another thing that can be done is I've seen just something on the agenda to discuss a matter and where members of the council will express their displeasure at something that happened or didn't happen. And so it's like and there could be as serious as a censure resolution, or something that says that, if somebody's saying some really horrible things, for example, you just want to disavow yourself from those comments, and you say, we want to be on record that we do not agree with Council Member X on his anti-Semitic comments or anti-Semitic behavior, or whatever the issue may be. And it gets, a lot of, there's no like one answer, and a lot of it is fact intense. And the best thing is, to talk about it with myself if you want to, or with the district attorney.
Okay, thank you.
Councilmember Rodriguez.
Thank you, Mayor Garcia. Going back to your PowerPoint, thank you. By the way, Hilda, this was great information. I think it's always good to have a refresher of the Brown Act. I know I've been doing it for some time now, but I'll tell you that I learn something new every time. So thank you. Something sticks. It's not that I learn you, something sticks, but thank you. So when we talk about the quorum on the traditional meetings now, it states that we have to have at least a quorum if anybody wants to participate remotely. I thought I seen that in your slides there, right?
Yes.
AB 361 removed that, and now this new AB 2449 says that if you want to participate remotely, you have to have at least a quorum in a single physical location of where the city is going to have that. Is that correct?
Correct.
Okay, so that's, I mean, it just reverts back.
It reverts back, not completely, but it reverts back, and with those requirements concerning just cause and emergencies.
Okay. Whereas now, obviously, that's not the case with AB 361.
Correct.
And just to clarify, AB 361 is not set to sunset till 2024.
That's correct.
But you're saying that it may sunset.
I will be advising you and other boards and commissions when the governor's declaration ends, and there could be unique circumstances. So it may be that we say we can't use it right now, but there could be a situation, something horrible happens, and you would be able to use it. So like you said, it still continues as law.
So is there one that supersedes the other? Because obviously that declaration hasn't been made. So would there be a point where this particular AB 2449 would supersede the AB 361?
No, I think they're both coexist.
Okay, so AB 361, as long as we continue to approve it on the consent calendar, and I decide to exercise that right to be from my home virtually, I don't have to give you a cause or emergency until you advise us, correct? Okay, just want to clarify. And last but not least, the emojis. I know a lot of us here, we are leaders in our community. We participate in different committees. But for example, to throw this out here, there's a lot of push to try to get our constituency to go out and vote. And sometimes it's for a certain initiative or measure or what have you. I don't know that it really affects the city council business, but it's more so, get out, might be a county, might be a state initiative. At that point, if I was to give a push out on a social media, and then some of my colleagues go out and thumbs up or an emoji, is that considered a Brown Act? Well,
if it's not, it would be if it's about a city matter. If it were about a city within your subject matter jurisdiction. If it's about some other measure out there, it would be okay.
Now, and I'll be very full disclosure of Measure T, for example. This is something that's a county initiative. But it also affects the city in some way, right? Because obviously they're recipients of some of those funds. So just want to clear this out. If I was to get out there and push for it, and you have folks thumbing it up here and there, showing their emojis or what have you.
I think that would be okay because you're not going to take any action on it. It's not like something that's going to come before you as a body to take action
Gotcha.
on.
So this is more, okay, got it. So I mean, initiatives that we're trying to get our folks to get out there, push. I mean, because I think social media is going to be here regardless. These platforms, no matter how you
Exactly.
see it, and this is how you communicate with your constituency, we just have to be mindful that, you know, there are certain triggers that we got to be careful with when it comes to Brown Act.
That's right.
And your recommendation is to avoid social media altogether?
On subject, on
Okay.
city matters.
Awesome.
Because she's on TikTok.
Yeah.
Councilwoman Gallegos.
Thank you, Mayor Garcia. Thank you, Hilda. I'm just going to piggyback on Councilman Rodriguez's AB 2449. I read on it, but I just want to get clarification from you that I did read, and correct me if I'm wrong, that if you were to do a virtual meeting because of some health reasons or something, the council that's here, the quorum here has to accept it. They can say yes or no. Is that what was I read in?
For the emergency, I think for the just cause, you just make sure you just let them know, right?
Right. So
I'm going to be needing to really delve into that a little more and give you all and my other clients a little more information because it can be, it's a bit thorny. Yes.
Yeah.
And it's something that's available. And if it's available and AB 361 is no longer available, especially at that time, it's going to be important for me to give you more clarity.
yeah, I just need the clarity of that. Whoever's on the dais makes that decision of yes or no. I think that's what I read, that if that person wants to zoom in, this dais has the ability to say yes or no.
Right.
Okay. The second thing is just to make it clear again, if we were to get a cell phone message to all of us, if people were to reply and comment on another reply, that's not what we should be doing, correct?
That could be a serial meeting if it's about city business.
Yes, it's about a city business and we have people replying, hit reply, and then they reply off that.
Right.
That's considered.
And since I have the floor, one of the items we'll be talking about is in one of our sessions are the Public Records Act. And I can tell you that's where it gets really, really thorny and difficult. Lately, I have many clients that are just like spending so much just responding to Public Records Act requests because they're asking for emails, text messages that exist and those that have been deleted. And there's a requirement for retrieval of those kinds of text messages. So don't feel like, oh, as long as I delete it, I'm okay. Just be very, very careful. Another topic that your city manager and I are talking about are the whole issue of cell phones and whether they should be personal or not. Again, that's another subject for public records, but we'll be delving into that.
Okay, perfect. Thank you, Hilda.
Councilmember Rodriguez, emojis again?
Yeah, thank you. So, I like these workshops because we ask questions and I see a lot of audience out there that's going to be asking anything. But anyhow, I want to bring an example. You brought it up, the spoke and the chain. So I'm going to use an example and you tell me if this is a Brown Act. I'm assuming that it is, but I just want to make sure I clarify this. But I happen to speak to a council member, let's say Council Member X, and I tell Council Member X that, I'm thinking this is coming through the agenda. So far as a 7-member body, I'm good there. Councilmember X then delivers something to Councilmember Y and says, and that's because of maybe my influence. Maybe they went out and said, you know what, don't know if the talking or specifying that you spoke to the previous council member has anything to do with it or not. But if that council member goes out and speaks to another council member and somehow influences or says, hey, I was persuaded to think this way. Now there's 3 people involved. And then that other council member Y then speaks to council member, let's say Z, for example. And at that point, once it reached that 4th person, that's your Brown Act violation, although they don't know that it came or it originated specifically.
It could be, again, and I hate to, be lawyerly, but it's a gray area sometimes depending on how much, if the person says exactly in that first one from X to what A or whatever.
X, Y, Z.
Yeah, if
Yeah.
X gave the information to Y and Y then gave that, said he is voting on this particular ordinance, or he's totally against it, and tell somebody else, and we should be against it too. That's 3 of us. And then they talk to one more person, then that triggers a serial meeting. It's tough. It's tough because sometimes you're just talking one-on-one, and
Yeah.
you're talking one-on-one is fine.
Of course. And I bring it up because a lot, this is a 7-member body. And I think, for some of us, it's okay to reach out to council members and talk about it. So as long as we remember that you don't reach out to more than 2 other council members, right? I
Right.
mean, if you want to ask a question regarding something else, because I don't think you should be discouraged from talking to other council
Exactly.
members. If anything, I think it helps in understanding. If not, you can always reach out to the city manager, but know that there is a boundary that once we cross that 4th or we get to additional members, and that's already in violation of the Brown Act.
And I always had a problem too, because 4 of you could talk to the Madera Times, the Madera Tribune about something, and then they publish it, but that's not a serial meeting. So, it's, but that's what the law is.
Well, just clarity.
Yeah.
Thank you. Appreciate that.
Thank you. Anything else?
This is the time to do it. It's a good workshop. I think it's always good.
One of many.
Pardon?
One of many.
Yes, this is, so in that regard, if don't have any others, or members of the public don't have any questions on the Brown Act, we can go over some of the future training real quickly.
Are we going to do them in that order, or are we picking?
They're not in that order. I think the one we want to bring back, because it's almost ready. And I know when we talked about it, I said 80%, but so many things have changed, and you have so many things that are a bit different. It's taken a little longer. So your city manager, city clerk, and I met on my first draft. And right now, I think I'm on my 3rd draft, and we're supposed to have a meeting soon, see if we can bring it back at the next meeting, or at the latest, the first meeting in December. So we're hoping for the city council rules of procedure. And then one of the ones that we also have been talking about is relationship building among the mayor and the city council. And for that one, I think we broached that one when we had our initial direction on this. I think for most of them, we can present, but I think for that one, we had recommended that we bring in a facilitator, somebody that really knows how to work with people and bring them out and ask questions. And so that would be more of a collaborative type of a session. And for those kinds of sessions, what councils usually do is also have them on a Saturday morning. It just lends itself more for something like that, instead of having it on an evening. But that, again, it's up to the majority of the city council to decide on that. And then, so then the others, the ethics and conflicts of interest, that can be taken care of in a session like this, where we don't have too many other things on the agenda, and Public Records Act, due process and fairness. And that'll also get into conducting hearings and why certain hearings require some things and others do not. And then there was one that it was technically not governance, but it was something that some of you brought up when we had that, as far as direction. And I know that the city manager has received a lot of inquiries about having a city events policy and the use of a city logo. And for those, we have we're looking at some samples, and the city manager and city clerk will be instrumental in those. The other one that's not listed, also that we hope to be part of the council rules of procedure, but maybe like a subpart, is proclamations. Sometimes, depending on what the issue is or the group is, sometimes I have found that there are disagreements among council, and it makes it hard to be given a proclamation on behalf of the whole city council. So it could be a tough one to look at, but we're looking at that one as well. if you have anything else, or Arnoldo, do you have anything else to suggest or?
Can thank you, Hilda. Not off the top of my head, I think one of the items that's probably kind of comes up most often is the use of city facilities. As council's aware, we've been very, very generous with the use of city facilities for various nonprofit organizations. However, I think it'd probably be best for us to collectively can decide, and when I mean we, I really mean the city council, to provide some clear direction on that. I think some of them are easy. For example, if the food bank approaches us, I'm not too sure if anyone's going to say that's a bad idea. That's a great idea. However, there are some other nonprofits that could be interpreted slightly different. And I simply want to make sure that I'm not out of line, or that I properly advise staff when different groups contact the city, because at times some of these events happen on the weekends. And at that point, staff is allocating resources to be at the event to set up. And again, we've been very generous, I think, as a city in terms of my time being here. In terms of those city facilities, I simply want to make sure that I stay in my lane, and that I'm not necessarily misappropriating, but just to make sure that we have clear direction from council. Thank you, Hilda.
Thank you. Yeah, that definitely, and I neglected to add that one, but that's definitely one that I think I know Arnoldo has had questions, and it is always helpful to have some rules, and because you do have a small staff, and at some point, if you have 10 organizations wanting something on a weekend, and do you have to pay overtime, for example, things like that. Those are the kinds of issues that have come up.
So I'm sorry, and I need to ask this because you brought up a good point. Is that something that we're going to cover within like policies and procedures? You have city council rules and procedures, but where would you see that?
That would be probably a different. Some of these will be like different resolutions and policies.
And I think that is key for us as a collective body, is to understand how we give direction to our city manager. Not so much as an individual, but as a collective. If
right.
Regardless of what events take place, I think that if that's going to be a direction, then it still has to come through council, or at least some type of policy that we have that, yeah, this is how it's supposed to be executed if we are going to go this route.
Right, and that one would come under mayor and council members' roles and authority.
There you go.
Okay.
Thank you.
Thank you.
Thank you. Thank you.
Thank you very much, Hilda. We will now move on to item A2, discussion and direction regarding developer request to add a rolled curb standard to the City of Madera standard plans and specifications. I believe, Mr. Helmut, you have this, or does Will?
No, that's right. I'll take it from the beginning, and then will pop in later in the presentation. Thank you, Mayor.
Thank you.
Again, this is a developer request to add rolled curb standard to the City of Madera standard plans and specifications. There it goes. Okay, the purpose of this workshop is to consider the request to add the rolled curbs to the City of Madera standard plans and specifications, and to provide direction based upon staff report and discussion during this meeting. The background is this is a workshop that follows up from the meeting, I believe is October 5th, wherein we were asked to go ahead and bring this back to the City Council for further consideration in the form of a workshop. Today, and by the way, this report will largely follow what we did at the last meeting, though it will be in a workshop format. So a lot of this will be a repeat. Today, the city has a traditional 6-inch curb that is found throughout the community. The city does not currently have a rolled or wedge curb standard. Rolled or wedge curbs may have a number of advantages and disadvantages based upon input from developer and neighboring communities. This is a traditional 6-inch curb. It is of course vertical. This is a rolled curb standard from, I believe I had got that from the city of Sacramento. It essentially looks like a roll. And these are rolled curb examples. Both the lower and upper photos there show examples of that. This is a wedge curb, and like the roll curb, the names typically imply what they look like. A couple more wedge curb examples here. And this is actually a street where you see standard curb on the left and wedge curb on the right. Some of the advantages for using rolled or wedge curbs is they're less expensive to install. Long stretches of curb can be installed without the need to manually form separate driveways. They're easier to accommodate ADA accessibility behind driveways. The ability to complete curb installation without risk and associated cost to move previously constructed driveways if they somehow do not align with the future driveway. So when developers initially build in subdivisions, they will install their curb in large areas, and they'll set the where they anticipate the driveway to go. And if the model home goes in and it's not quite perfect with that, they find themselves cutting out an existing driveway and placing it into another location. Going on with the examples of advantages, they help to prevent water from weakening the substructure by not utilizing saw cuts to remove the old curb and gutter for installation of new driveways not envisioned during the initial curb construction. So essentially, they're literally cutting out the driveway and then replacing it with standard curb. They may help prevent tire and wheel damage to vehicles parking at the curb. The disadvantages, damage to the curb or the sidewalk. Where sidewalk is contiguous to the curb, sidewalk is easily parked on, representing a possible future repair cost to the city or the homeowner. Accessibility, mounting of curb or sidewalk can result in sidewalks being obstructed to pedestrian or wheelchair passage. Damage to street furniture, street lights, fire hydrants, valve boxes, and other appurtenances have greater potential to be damaged as they are more easily accessible to cars when they jump the curb. Landscape damage may allow for driving into landscape areas. Vehicular damage, depending upon the curb type or design, owners of some low-profile cars may discover that their cars bottom out in the driveways, causing damage. These are examples of contiguous curb, sidewalk contiguous curb. The one on the left is the sidewalk directly up against it, and to the right is actually 4th Street. The formal sidewalk is to the left, but you can see that you can walk on the stamped concrete there to the right as well. This is detached sidewalk. Literally what it means is you have the curb, a landscape strip, and the sidewalk. A few more examples of detached sidewalk in different areas. To the left is more standard what you saw in the previous photographs. To the right, you see a little bit more of a change. You'll see a meandering sidewalk up above and park strip areas with more formal landscaping rather than grass. The disadvantages, continuing on, the vertical barrier curbs are generally recognized as a deterrent to leaving the travelway. Rolled or wedge curbs by their design represent less of a deterrent. Drainage, rolled or wedge curbs are shorter than their standard curb counterpart. Shorter curb heights result in less stormwater runoff being retained in the street. So there's larger storms. There's more potential for the water to raise up to a level that it moves beyond the curb and into the private property and possibly covering up portions of the sidewalk. We did contact a few agencies as part of this, contacted Fresno, City of Fresno, City of Clovis, and Madera County. The published standard for those are Fresno has a wedge curb standard. Visalia, they were not contacted directly. They have a rolled curb standard. And then City Clovis and Madera County, they allow wedge curbs, but they don't actually have a published standard for those, but they're fairly regularly used. Some of the input we received, accessibility mounting concerns were expressed, pedestrians in the ADA, potential impacts on accessibility. Fresno Clovis did note that no concerns were expressed or volunteered from Madera County and Visalia through the other contact at Fresno. Additional input received, street furniture. Damage is seen as a concern. Fresno Clovis has seen damage as a concern. Madera County and Visalia, again, we don't really have anything on that. Maintenance costs. The answer was yes. Fresno, Clovis, and Visalia. There are maintenance costs associated with that. Madera County didn't express any concerns with regard to it. Drainage, the only agency that discussed drainage was Clovis. They indicated that the flood control district, which covers City of Fresno and Clovis, they require closer spacing of the drop inlets, so they're able to intercept the water more frequently before it builds up to a point that jumps over the curb. Our police department was contacted. They have no they have no comments on rolled or wedge curb, essentially because we do not have really any examples in the city. With regard to enforcement, we don't really have the staff to do that right now, so they would not be able to enforce. Now, since the last meeting, I indicated at the last meeting that we had not spoke to the ADA Advisory Council yet. Since then, I did meet with them and worked through a shorter presentation here to go ahead and indicate the question, and they did provide some input. I'll refer to them as the AAC from here. The AAC believes roll or wedge curb represents a safety issue with regard to pedestrians. If additional floodwater tops curb, it may represent an accessibility issue. Generally speaking, the floodwater portion, it might place about an inch or so on the sidewalk. I don't know that would be an impassable situation, but there might be water on the sidewalk. Cars parked on the sidewalk can block accessibility, visibility issues. As described by the AAC, it appears as though the concern was associated with pedestrians or people in wheelchairs needing to go around cars in the street if the sidewalk is blocked. In other words, if the sidewalk is blocked, they might step out into the street and then they'd have to look to the left or right around a parked car. The level of support on a vote of 6 out of 7 AAC members, the AAC does not support rolled or wedged curb, even with park strips separating sidewalk from curb. And they state that safety should be prioritized. These are just a few examples of the sidewalks where what it looks like when cars are parked on them. Some of the potential options that the city could have if the city chooses to allow rolled or wedge curbs. Each of the following may mitigate certain concerns by virtue of cost, detract from attractiveness of using the rolling curb. So it's allowing a wedge curb rather than a rolled curb. That is one example. I think that I know that the standards used by Fresno, Clovis, and Madera County are wedge curb, and one of the reasons might be that they're less jarring to cars. The rolled curb tends to be more abrupt. The wedge is one step, and the rolled curb is a little bit of a down then up motion. Additionally, require base rock where the sidewalk is continuous to curb. Based on Fresno measure this is based on Fresno measure to reduce the damage. So when cars park on curb and sidewalk, generally speaking, our curb and sidewalk standards, those are placed directly on existing soil. They're compacted to the point where they more readily hold up to a heavy weight, but if continuously exposed to vehicle weight, they might start to go ahead and give way a little bit. Installing base underneath the sidewalk and the curb can go ahead and prevent that from happening, or at very least reduce it. Also require meter boxes to be traffic rated. When a vehicle jumps the curb, the meter boxes are generally a few feet back and they're not designed for traffic. If a car tire gets on them, they can crack. Then to protect street furniture using vertical curve. That's wherever you might have street light or fire hydrant light or something like that, you can conceivably require vertical curve a certain distance in front of it and behind it, in the hopes that a car wouldn't drive along the sidewalk up to the point where they would hit that street furniture. The city of Fresno does that. I don't have the standards for that though right now. Then require park strip separate. That would be to protect the sidewalk from the curb. So if somebody jumps the curb or wants to park on it, they have to go a fair distance onto the private property to go ahead and actually block the sidewalk or cause it to break down. And then enforcement, when practical, utilize enforcement. From here on, Will Tackett will go ahead and give a presentation with regard to yard areas and aesthetics.
Thank you, Keith. If you don't mind flipping slides for me. So thank you. So what, some of the concerns that we heard at our earlier presentation on this item on October 5th from the council were whether or not the adoption of a rolled or wedge curb standard would have the potential to adversely impact the aesthetics of our neighborhoods or our streetscapes. We've heard from Keith's presentation that there are concerns about whether or not a wedge or rolled curb would encourage cars to park over sidewalks. We also heard concerns from some of the council members as to whether or not that may encourage parking in the front yard areas, the private yard areas of homes, because you essentially have a mountable surface versus an isolated drive approach connected to a driveway location. Next slide, please, Keith. So the next several slides, I'm going to show some examples of various streetscape treatments as well as yard treatments. We'll talk a little bit about how the potential, one of the options that were presented insofar as the council's ability to adopt a text amendment to more clearly define landscaping standards may discourage some of those issues from occurring. Not all of these photos will represent a wedge or rolled curb, so I would just invite the council members in each of these instances to imagine a wedge or rolled curb as the respective application to the streetscape. The City of Madera's municipal code, as it relates to parking in front yards, does not state that just that. What it does do is prohibit parking on unpaved surfaces. So one thing that might be considered in the adoption of front yard landscaping standards is how much of the front yard may be paved. The image on the left shows perhaps a worst case scenario where you have contiguous properties all paved from their stoops or the front of the structures out to the right of way. And there's actually a sidewalk pattern in there. It's hard to distinguish, but it just becomes basically a sea of concrete in that front yard. And with respect to a concern on parking over the sidewalk and whether or not a rolled or wedge curb standard, especially if a front yard area is paved, may encourage parking in those front yards or vehicles blocking the accessible path of travel, the image on the right is a good example of how it may do so. Again, if appropriate standards are put in place to control front yard landscaping and pavement. Next slide, please, Keith. So here's a couple of, here's one local example, and staff wants to be clear, this is in no way an effort to admonish these property owners. Aesthetics are subjective, as well as the interest in a private property owner to improve their property. They may be water conscious, and we hope that they would be, and therefore less maintenance with the landscape area may be desirable. They may have some accessibility issues themselves, prefer to park closer to their front doors, have some fear for safety. And again, the maintenance of landscaping. So there may be a desire by private property owners to pave their yards. And here we see a before and after photo of a home in Madera. Now, I also want to be clear that the image on the right is post inclusion of sidewalks. So the image on the left does not have a sidewalk along the street frontage or the curb return at the corner. The image on the right does. And so that makes the amount of pavement shown in the image seem a little bit more extensive, but you can clearly see on the right-hand side that the front yard area is entirely paved in this image, and we have a vehicle parked in the front yard. I think the introduction of the sidewalk on 4th Street there probably necessitated the removal of the street trees. Staff would encourage a shade canopy for our sidewalks, whether that's on the private property side or whether or not it's in a park strip where we have a detached sidewalk. It's a much more inviting environment for our pedestrians and would better encourage alternative modes of travel to the automobile. Next slide, please, Keith. This is another local example. Image on the left is the before photo from years ago, and the image on the right shows that, in this case, up to the rear yard fence, the entirety of the front yard and street side yard have been paved. So you can clearly see an example of the difference in the aesthetics here. Again, aesthetics are subjective. but staff would posit the image on the left is a much softer look. The image on the right is also an example that I think contributes to the point Keith was making about the curb's ability to handle a specified volume of runoff. Many municipalities implement lot coverage requirements, so it restricts the amount of impervious surface, whether it's rooftops, structures, pavement on a site, and that's really to control the amount of stormwater runoff that is going into the storm drain system, as those storm drain systems are designed with a certain capacity in mind. Now, one home here or there probably doesn't make a whole lot of difference, but if we had a situation which was perpetuated through a neighborhood where what you saw on the right-hand side was the classic example for most of the homes, we would certainly see an increase in stormwater runoff to the extent that it may adversely affect our storm drainage system capacity. Next slide, please, Keith. So these are some images from Fresno. This is a neighborhood adjacent to Fresno High, and this is an example of where an aggregate was used to fill in both the park strip and the entirety of the front yard. And as in many cases, we see examples perpetuate. So this is an area close to my own neighborhood. One of these yards was first modified to include the aggregate, and then you can see a little bit further down the street, another home did something very similar. And then the home in the center is not an aggregate, but landscaping has not been maintained or even planted in that instance. And the image at the below kind of shows what effect that type of an application can have on the overall streetscape. Granted, there aren't many trees on this segment of local street, even on the east side, but you can see a pretty stark contrast between a full application of an aggregate, or even if you were to look at that as a paved surface, what impact that might have on a local streetscape. Next slide, please. This is a local example. Again, this is an aggregate base applied to the front yard. Now, I'll venture to say that this is a much better attempt. What it does do is illustrate that you can introduce elements to an aggregate application which would help to soften that. I don't know that this gets all the way there, but it's an effort. And staff wants to be clear that whatever direction the council provides, there are options which would allow for a diversity of applications. I don't know that it is anyone's intent to require something completely uniform. The first image since I picked up the presentation is another street in my neighborhood, which just has a beautiful shade canopy, mature trees, very uniform within the park strips along both sides. It's not a one size fits all, and that may not be everybody's cup of tea. So there are ways that you can apply different composition or components to a front yard landscape to break things up. It can limit the amount of water that's required for irrigation. It can limit maintenance. But again, this is another example with the front yard, which is devoid of turf, a local example. Next slide, please, Keith. So we did hear the concerns about cars parked in front yards and park strips. These are just some images of how that can occur. Go ahead, next slide, please, Keith. So these are some examples. Now, while there's no sidewalk in front of either of these homes, these are good examples of how the application of a landscape treatment can discourage parking in front yards, even where you do have a rolled or wedge curb. You can see from these images the type of planting is not as inviting as turf would be to park a car, or maybe even be preventive, such as with the mounds on the right-hand side. Certainly, you wouldn't want to park your car in either of these yards, and I don't think someone visiting the home would either. The image on the left also, I think, provides a good example of how landscape areas can clearly demarcate the purpose for areas. So on the image on the left, you have sort of a median or an island landscaping area, which separates the driveway from kind of the pedestrian front walk. Again, these are just examples of types of landscaping applications which could potentially discourage, again, parking vehicles in front yards. And these can be these types of landscaping applications can be controlled through codified provisions within your municipal code, but again, provide some diversity to a homeowner to apply the type of landscaping that they prefer while still accomplishing the goal of discouraging to get parking of cars in front yards, et cetera. Next slide, please. So this is a local example of where a park strip has been covered with pavers. So again, in this instance, what I'd ask is that you imagine if this were a rolled or wedged curb, probably more inviting to a car mounting, driving up into the yard or parking on a sidewalk, or at least half in the street and half above the curb. Next slide, please, Keith. And here's some examples of some diversity in park strip treatment, as well as an example of applications which would discourage parking over the curb or mounting the curb to park the car up in yard areas. So again, I think a good example of the diversity of landscapes. Again, we'd want to encourage shading where possible, but this type of landscaping would discourage cars mounting the curb into those areas. The image at the bottom right also shows how the combination of lower level plantings as well as street trees can be provided in combination, both to discourage that type of thing happening. It's also important to point out, while you need to respect the mature breadth of the trees at growth, the image on the bottom right does show a uniform application of street trees, which if uniformed with if applied with appropriate spacing, could actually be protective to pedestrians in the instance a wedge or rolled curb were utilized. Next slide, please, Keith. And these are some other examples of just some diversity in park strip treatments. Now, again, they can be very lush. They can be more minimal. The two examples on the left, I think, provide a neat example and a conscious one of how cars parked on the street can access the sidewalk. So I think there's probably a walkway on the opposite side of those purple flowers on the right-hand side. But one thing we'd also want to be conscious about is if you get something too lushly planted within the park strip, well, how does the passenger side or riders of the vehicles get out of their car? And I think the examples on the left show how some treatments can be made within the park strip in combination with landscaping to provide some paths of travel to the sidewalk or separations in uniform increments to facilitate that accessibility. And I think that's the last slide. So I will turn it back over to Keith to talk some more about those alternatives and solicit input from the council. Thank you.
Thank you, Will. And one of the alternatives to adopting a standard, which would be placed into the standard plans and specifications, putting in as a permanent standard, would be to adopt a standard as a pilot program. That would be for a specified time frame. It might be 2 years or 3 years, or even going back to 1 year. I wouldn't suggest a 1 year time frame at this point. Since most developments, if they started now, it would be close to 2 years before they even start to get to a point where you could gauge the results of a pilot program. So at least 2 years is the time frame in which I would consider that. Tonight's action is to consider this discussion and provide staff direction on future steps. What I've done is in the staff report, this is a repeat of what's in the staff report. This shows I'd like to think of it as a step-by-step through this, so to help council in considering whether to adopt a wedge or a rolled curb standard. We'll just take it through and I'll check the boxes, depend upon whether we leave this up on the screen or not. I will be checking these boxes. But the first question would be, is council open to allowing for a rolled or wedge curb? If so, what type of curb would they be selecting? Or what type of curb would you be selecting? And then if a curb is selected, are there mitigation measures that would be selected? And that includes park strip, base rock, traffic rated meter lids, vertical curb at street furniture, vertical curb on cross streets. Usually it's the main entry. Amend the code for landscaping, minimum landscape percentages, or other measures that you may have in mind. And then lastly, to go ahead and consider whether it would be a a permanent standard or it would be a pilot. With that, let's see, I think that was my recommended action was no formal action is recommended. So we'll skip right back to the other slide here. What I'm going to do is revert this here and allow for me to check this, or if council so desires, I will turn this off and just keep track of it separately. With that, that is the end of my presentation. Either myself or will be happy to answer any questions you may have.
Thank you very much. Thank you very much for that report. Elisa, do we have any comments under this item anywhere, any shape?
No written public comment, Mayor.
Or
Mark, anyone?
There's no one on Zoom.
Thank you, Mark. Anybody here in the public wishing to ask questions regarding this item? Any public comment? No. Then we will close public comment and bring it back to council. Council Member Rodriguez.
I believe Council Member Mejia was up first, so I'll let her.
Okay. Councilmember Mejia. All right.
Thank you, Keith. I believe that during one of the slides you had mentioned that the city of Clovis, they have drop inlets because to help with potential flooding. So would that be at the cost of the city?
The city of Clovis, the city of Fresno, and then believe portions of Fresno County, they don't govern storm drainage themselves separately. They have the Fresno Metropolitan, well, they have I'll call them the storm district there in Fresno. They will typically go ahead and design the systems, and when it gets into the subdivisions, they will go ahead and make specific recommendations or set minimums for that type of thing. So ultimately, it becomes the cost of the developer. As certain subdivisions get large enough, the amount of water that falls within the subdivision starts to accumulate, and the subdividers engineers will automatically start to design storm systems that extend into the subdivision itself. If it's a very small subdivision, you might not see a storm system at all. But if it's a larger one, the storm system will extend in, and they might do spacing on the drop inlets of 500 or 1,000 feet or what have you, depend upon the storm that they're analyzing. But if you do lower the curb height, then that distance would have to be adjusted, and the engineers themselves we would expect the engineers themselves to go ahead and reduce that spacing and account for it.
Excuse me, Mayor, if I may clarify a point, if that's okay. So the draining inlets, if you have a rolled or wedge curb, there's more inlets that are required because the street can accommodate less water in comparison to the traditional curb. The developer installs the inlet. At the end of the day, the property owner or whoever buys the property is probably going to pay for it. The maintenance of that inlet is borne by the city. So in order for so the city has equipment, the city staff goes out and we clean those inlets to make sure that the streets aren't flooded. So the developer pays for it. More than likely, I'm going to speculate that that cost is being passed on to whoever buys the property, because developers usually don't donate their expenses or their cost, I'm assuming here. And then the city would maintain it. So they build it, we inherit it. That's probably the simplest way that I can put it. So hopefully that answers your question, Councilmember.
Councilmember Rodriguez.
Yes, thank you. So I'm sorry, Will, if you may, at the rolled curb versus the wedge curb. I know that both of these have been a topic for us here. In your opinion and what you've seen, not only in the city of Madera, but even in Fresno, which one has the less potential of cars getting over it? Which one's less inviting between both of them? I look at the wedge curb as a, easy access, but when it comes to the rolled curb, it still has that small little bump there that will let folks know that, hey, you're coming over the curve now. Can I get your opinion on that? I mean, what you've seen, or maybe you, Keith?
Sure. For my part, I would posit that I don't believe any one or the other would encourage or discourage more than the other. I would say they're basically the equivalent. I'd have to defer to Keith and whether or not you actually see a elevation difference in the rolled curb from, again, there's sort of an undulation or an S in that, right? It kind of dips down and then rolls up and over, which might create a little bit of difference in height, which may be more discouraging to lower vehicles. But aside from that, I don't believe there would be any difference one way or the other between the two.
So the elevation is what I was getting to. Thank you for expressing that. Yes, Keith, that's what I.
Sure. I was just going to say I agree with Will. The difference in the roll curb height is it was a half inch or 3/4 of an inch or something like that. It's not a significant difference in height though.
Okay. So, you know, as I expressed the last time when we had this conversation, is that it seems like this has become, you know, something that has been, I don't know, more aesthetically appealing in some cases. I know that the other subdivisions out on the southeast Madera have incorporated these particular curbs. And I don't know if it's more of a, you know, you're trying to appeal to the client and to the customer. And I would hate for us to push away. And I don't know if it's just that component alone. Obviously, the developer has a lot to do with it and how you present your models, how you present everything else that comes with it. But if it's if it's something that people want and that's a market deal that we want to appeal to, then, you know, I don't think it's something we want to take away. I like the pilot, but one of the things that I do would love to incorporate, like you said, well, is to codify some type of measures that would allow for either landscaping, shade trees, or even some other type of aggregate that would discourage any vehicle from coming up top, and really codifying that so that it lies on the developer. Kind of like with these inlets that Council Member Mejia was describing earlier, is that, you know, if we had this particular type of curbs, then obviously it requires that we have more of these inlets. But again, that's the developer's cost. We have these particular inlets now with vertical, and we maintain them either way. Is that correct, City Manager?
Yeah, so the city, we currently maintain the inlets today.
So adding additional obviously requires possibly Public Works to be out there more. That's kind of where.
Correct.
All right. Yes. But other than that, it's passed on to the consumer. They look at it. They like the appeal of it. So they pay for the home that has that particular deal. But my understanding was it less cost to build a linear curve than it was to more of a vertical.
And that's my understanding as well. Now, if those inlets are damaged in the future, though, and Keith, feel free to correct me, the drainage fund, so the city's drainage enterprise fund would pay for any repairs to that. Is that correct, Keith?
The drainage fund can be used for that. I think the drainage fund primarily addresses those areas in the city that don't necessarily have formal improvements right now, but the drainage fund can be used for that, and it would impact the general fund, and by virtue of that drainage fund.
Yeah, thank you, Jamie. And again, I'll just leave with this here is that, you know, I want us to picture what Madera looks like 10, 15 years from now. And if we're not doing anything to market ourselves, to become the place to be, the place to reside, that compares to what's out there already in the market, then, you know, don't expect to attract the quality that you're after, right? You have to want to just allow for what the market's allowing, right? And if developers are doing this in areas like the Cerro Viejo or Riverstone, then let's not shoot ourselves in the foot and be reluctant to try to open ourselves to something different. Now, that being said, I certainly want to allow for like a hybrid where I get very discouraged when I do see cars parked up, and if they're inviting curves or these wedge curves, they're very inviting to do that, then this is where we codify. That's why we have council to have direction, right? We give direction so that we're not allowing ourselves and putting ourselves in a position where we have kind of what Will presented earlier in his slides. That's not something that I'd like to see, but I certainly don't want to discourage people from what the market's doing and what's out there, what's attractive. And I think that if we codify, we can potentially find something with the hybrid, and I like the pilot to see what that looks like. We can always come back and say that's not what we want, but there are areas in Madera that do have those rolled and wedge curbs. And in some areas, I've seen it in Montecito Park. They look very nice, very clean.
Councilmember Montes?
Yeah, I'm going to disagree with a lot of the points that Councilmember Rodriguez made. We do want to position ourselves, give ourselves, and I say this all the time, give ourselves a competitive advantage. But I do understand that there's a lot of concerns from my colleagues up here. And so moving forward with a lot of the mitigation measures, I know a lot of things we are going to inherit, but we're going to inherit them anyway, no matter what standard they're built to, right? So Keith, can you go back and put the that matrix up, or the I guess the options? There you go. So I guess it would be, so allowed roll curb with mitigation measures. And I don't know, even if you guys put something together, staff put something together, that would still have to come back to council for final approval, right? So I would like to see, I guess, mostly pretty much everything on here, so that we can truly address a lot of the concerns of our colleagues. Because I'm not gonna lie, I still do code enforcement. I've done code enforcement, and those are some of the I don't want to say the worst violations, but they're just the reoccurring ones. You can go all the time and address it at the same property, and for whatever reason, people just don't care or learn, right? But if we can do stuff, if we can put that on the developer, say, hey, we got some mitigation measures, because some of the stuff that you showed, Will, was really nice. And it could have been new. I think some of it was a little bit older, or it could have been the property owner's prerogative to do that and make sure that they have a nice property. And we know that's not always going to happen. And whatever measures the developer takes over time, we know that they're going to deteriorate. So I would be in favor of putting pretty much all these measures, as well as making it a pilot, so we can actually see if we see that some of these areas start deteriorating relatively quickly, then we say, okay, well, these mitigation measures are not working. We give it a try, and then we can move on. So that does also include the amended code for landscaping percentage. I thought we did have a percentage already. Will, am I mistaken, in the City of Madera's code that we don't have a certain amount of open space that's required? I don't want to put you on the spot. If you don't know it, that's fine.
No, and we can defer to perhaps Gary for some more info on that. There are provisions in the code which identify what areas are to be defined as private yards, but I'm not aware of anything, at least in my time here, that really allocates what the composition of planting may be. So we're talking about a ratio or percentage of what is permissible to be paved, because again, the Madera Municipal Code only prohibits parking on unpaved surfaces. We don't have anything that addresses what portion or percentage of the yard may be surfaced with a non-plant material versus a plant material. So again, there's probably, whether there's provisions or not, I would suggest, if we're going to move forward and the concern is the parking in the yards, to take another look at that and see if we can more clearly define or codify provisions which would facilitate landscape treatment, which would discourage that type of parking in the front yards. And there, in my opinion, there are ways of doing that.
I think we should move forward with that anyway, because most of the examples you showed in Madera actually didn't have a rolled curb, and they were doing that anyway. And that was another challenge for code enforcement when I was working here. The last thing was, if somebody did do that currently, they paved their front yard, would they qualify for reimbursement on drought tolerant landscape?
That's not something I can answer. That's something we can report back to the council.
I'm going to speculate and say no.
Okay.
Um,
Because if that was the case, I think we should, regardless of what we do here, we should probably correct that and not incentivize that.
Absolutely. I wholeheartedly agree with you. And then also, I think Madera does have some rolled curbs and some private subdivisions that are gated or they're not public streets. I can't think of a single rolled public street in the city of Madera. There's private apartment complexes, condos, or private developments or private roadways. The nearest public road with the rolled curb that I can think of is in Parkwood, on Parkwood Avenue. It's half a block on Parkwood Avenue on one side of the road. It has a rolled curb with an attached sidewalk.
Is there a small development on Granada and Riverview?
Granada and Riverview?
Some
Townhomes there.
townhomes there. I think
Yeah,
they have
townhomes.
it,
Those are probably
but they're not
private.
gated.
Yeah, okay. Yeah. Most of those are
It's a public
private, if I
street.
recall.
Yeah.
Oh, yeah.
Public street though.
Oh, is it? Okay.
All right.
Yeah, it's kind of, so there are
Very
examples
small.
here and there.
It's a very small development. I think it's like
Yeah.
like a half a.
Oh, is it?
city
Oh,
block or
okay.
something.
Yeah, so there are a couple of local examples here of some varying kind of styles, I think, in the city.
They have a very steep landscape area, so I think it's not really. You can't really. It's like parking on the side of a mountain. So people probably don't do that there for that reason. But that would be my recommendation, in my opinion, is just for staff to come back with that, and obviously council is going to vote on the final.
Councilmember Rodriguez, I just wanted to ask one question before I pass it on to you again. Is that okay?
Sure. No.
Okay. Regarding the word pilot, a pilot program, let's say that the developer was allowed to establish a pilot program under this provision. If that then was overturned and says, no, this is not working, who would be responsible for paying for the pilot program? Would that go back to the developer and then reverse what was done? Or would that be the city?
I'm going to speculate that once the curb was installed, if the council were to decide to remove the program altogether, that curb would stay there in perpetuity. I think it would be cost prohibitive for the city to go back out, remove the curb, and then reconstruct the 6-inch curb.
So we can strike the word pilot from this if in fact it.
Right. So council can put a sunset clause on a program and to say hypothetically, of course, any development within the next year can try this, but then after 1 year, we're going to hit the pause button to see how they're developed. And then depending on how they're developed, one thing the council, and I don't want to muddy the waters here. However, a subdivision map could be approved today. That subdivision may not be built out for 10 or 12 years. And so that's just something to kind of keep. I think if memory serves me, the longest map that can be extended, I thought I read a court case going a number of years. I think it was 18 years if memory serves me. Probably even 20. Okay. So that means a map was approved by community. The subdivision was not built for 20 years. After on year 21, they started building. So that's just something to kind of keep in the back of our minds.
I kind of got a question on that. Can I ask that real quick? Just on the
Go
subject?
get on
Piggyback.
that.
Do you think that because if we do, and semantics, right, pilot program or sunset clause, if we do that a lot of people are going to be like, I want rolled curves so bad. I'm going to do all my plans right now, get them approved and sit on it for 18 years.
Probably not.
Okay.
Probably not. Yeah.
Gotta ask the question.
Yeah.
So that was just one of them. Okay. So I'm just going to.
Please go ahead.
Yeah. Thank you.
This is
Thank
your
you.
show.
Because I want to acknowledge the fact that, yes, you did raise your hand. But,
You're good. You're good.
so I wanted to talk about that because there's, in essence, there's no such thing as a pilot program. If it goes into play, it's just going to stay there regardless of what happens. The second thing is our police have notified us that they have no capacity to be able to police the parking of on sidewalks and or parking on lawns. That is just not it's not going to happen. The safety of the pedestrians having to again it's similar to when there is no existing sidewalk at all, where pedestrians have to walk onto the street and navigate between cars to be able to get from point A to point B. And that disturbs me also. If folks continue, like the ugliest photo that I saw right now was with that completely paved front lawn. That was completely not what I would like to see Madera become. I like the idea of putting landscaping to deter. That's one thing I did like, but that did not mitigate the water issue. We have flooding right now in our city when we have water going over the curb and onto people's front lawns and up to their front doors already. And it just seems to me the few times that we do have rain, and I understand that we don't have rain all the time, is that we would have more flooding over our sidewalks into our front lawn. So I'm not convinced that this is the way to go. And I understand your point regarding beautification and making something look different. But at the same time, I'm not convinced that this is the way to go in order for us to do that. So I just wanted to say that. Thank you. Mr. Rodriguez.
Yes, thank you, Mayor. So I want to comment by saying that we really can't control what took place in the past. We can't control what planning in the past, because now you see it with some of the pictures, regardless of it being vertical curve or rolled or wedged, you still have the issues. And as a code enforcement officer, I think Councilman Montes can attest to that, because it's everywhere. I see it around my neighborhood that has a vertical curve and they still park in the yard. And I mean, obviously that's not something that we can control. Obviously the lack of staff to be able to enforce that's going to be whether you have this rolled vertical or even the wedge, what have you, whichever one. I think you're still going to have those issues because there's a shortage in staff, right? But I think we as a council have the opportunity to create something different. Obviously we're not the past. We can't correct the issues that have arose from the past, but we can certainly we can make those better. And this is how you codify things into our ordinances, is so that we have that opportunity. I would only recommend that this be done to subdivisions. Of course, you know, we have concerns about streets. I mean, I don't think streets is even at the table for conversation. I think this is more for developers that want to develop subdivisions, that want to be inviting to their clients aesthetically and appealing. So I certainly would not support anything outside of a subdivision. And a pilot, again, in a sense, you know, that's exactly what it states. It's a pilot. It's a period of time. You're going to try something to see if it pleases the community, not necessarily me, but the community, because this is what the community says. If you haven't heard what the community is saying about, well, why can't we be more like this? Why can't we be more like that? Well, we have an opportunity to make that change. And this is where we make it. We make recommendations here. So it's not so much that we're trying to bring something new or different. It's we can make it how the city of Madera wants to make it. We can design that how we want it to be designed. We don't have to be exactly like Clovis, exactly like Fresno. Again, to Will's point is we can codify it with certain provisions that would allow a certain landscape or structure and what have you. And the water issue, again, that's being mitigated by the additional inlets that are supported to be able to mitigate for those issues. But overall, I think we certainly have an opportunity to make design our city in the way we visualize that. And I envision that as a city that's inviting to folks from all over the place that would in a blink of an eye pass Madera and look at Clovis. Well, now we have something in the competitive edge where we can say land here. And if it's a problem, shoot, I'd say do it on Village D. Do it on Village D or do it on specific, I don't know, facility districts. Do it on certain districts that may appreciate that more. Right? It doesn't have to be everywhere, but I think if you're going to open it to all. That's just my comment.
I lost track of whether you already made your comment. Mayor Pro Tem Evans.
Yes. In reference to the roll curb versus the standard, you know my stance on it. And I have lived in areas where there have been the roll curb and it's a flood area and the homes have flooded. And if there's nothing to buffer it, to stop it, it's going to just continue to roll on in. Where at least if you have a standard curb, it does have a chance to at least hit the curbside and continue on down. Not saying that it's not going to continue to graduate into the yard. It can still do that. But at least this way, there's a buffer for it to stop. Also, I understand that there's other areas that are being built here in Madera. And I understand that the areas that, just say particularly where I live, we do not have very many sidewalks. And we do have people parking in the yard, half on the curb, half off the curb. The children are having to walk around because there's no sidewalks. And at least if there's something to stop the car, when the car decides to jump the curb, if it's something to stop the car, the kids there won't just necessarily be trampled. I've seen a child where the car rolled down the driveway and the child was behind the car. The child had to rest in peace because he was no longer. So, I mean, it's an option, but all I'm saying is from where I sit at and from the area that I am in, and that's the area that I'm over, the standard curb for my area. And that's all I can speak of. But as far as the city of Madera is concerned, who's to say? But I'm just not in agreement with it. I'm sorry.
Councilmember Rodriguez.
Yeah, I just want to emphasize that this is not on existing curve. This is on new development that would come out, whether it be in any area. I don't think it's really specific to any district in general. This would be a citywide effort on new development. So that's what's being presented before us. I don't think we have anything with the existing curb on the table. And I just want to clarify that is what we're talking about, correct, City Manager?
Correct. This would only apply to new development. Another potential option that I'm not actually sure if it helps or further muddies the waters here, but council could even potentially put a size or project size limit on it. So for example, council could say, we're going to try a pilot project to a subdivision that's, I'm going to throw the number 40 acres. That's very large, probably too large, or 20 acres. So then you don't have an infill project that's in the middle of the street, sandwiched between a handful of homes. And then all of a sudden you have rolled curb. I'll give you an example. Somewhere where it probably wouldn't be appropriate is on Malone Street, where the city had the 5 Habitat for Humanity homes. The entire neighborhood is traditional curb. I don't believe that it would be appropriate to introduce a rolled curb for 5 homes. However, if you do it on a larger scale for a clearly defined geographic area, maybe that's one potential option.
Yeah, thank you, Arnoldo, because that's exactly to my point is that that's why you codify, and you can be specific on certain particular, already developed communities or what have you. But when you have a blank canvas and you're able to start from scratch and you're able to design something, this is a city that's almost practically a city that can be built here in the next 10, 20 years, or at least the size of population that you're expecting, is that you make it look very attractive, appealing, because it is essentially a part of the city. And we can be proud of something that we've collectively decided on, right? So it's not, again, I just want to emphasize that it's not on existing curb, but this is on new development. And to your point, I don't know, I think you bring a great point. Yeah, if it's something that doesn't kind of correlate with what's in the vicinity, then yeah, but we write that somewhere, right? That's something we can put in the ordinance or what have you, in a provision with those measures. And I'm all for that. I'm just saying that, hey, let's not take away our opportunity to do something that's very impactful for our community. And those are my comments. So thank you again, Mr. Mayor, for your time. I want to thank Keith and Will for their presentations. Appreciate everything you brought forward, because I think that really helps us be informed how we come about making decisions and giving direction for this particular item.
I think I saw Keith typing. I don't know if he added that to his list in real time.
I have not.
Well, the main thing is, as you noted earlier and during the Brown Act presentation, you talked about direction. So I think this evening somebody needs to make a motion on what that direction should be, because I've heard persons on both sides of the issue, on multiple sides of the issue.
So I'll make the motion that we move to have staff put something together with allowing the roll or wedge curb with all the mitigation factors, including the one that our city manager had talked about making sure that it's not in an already developed area. So it's all new development. So that council can come and vote on that in the future.
I second that.
And also for a short period of time, 2 years.
I like the idea. I mean, it's not something that we're taking on today, but if, like you said, if council can bring something back, I think it just becomes more and more attractive. I certainly agree. I second that.
Motion to put into place a 2-year rolled curb with mitigating factors for 2 years in non-developed subdivisions.
So just to clarify, this is not to put it in place. It's for staff to prepare something so that we can come and vote on it later.
Another recommendation.
Yes, so I believe the direction would be for staff to prepare a rolled curb standard with mitigation and to bring that back for council deliberation at a future date.
Yes.
Right, including any potential code amendments specific to front yard landscaping requirements.
I'll second that.
Oh, yeah. All right. Anybody else want to make a motion?
I second.
Okay, that too. All right. So are we clear? Do we need to clarify anymore, or we just go ahead and take a vote? I just want to make sure that everyone knows that what we're voting on.
Yeah, it was on record. I think Arnoldo said it best and cleared it. That's exactly what.
All right. What he said. Yeah. All right. So it's been a motion and second it. Alicia, would you call the roll?
We're all here.
Councilmember Gallegos,
Oh, I'm sorry.
Oh,
Yes, we are. We are all here now. I forgot that you had come in. So there's a motion on the floor. All those in favor say aye.
Aye.
All those opposed, nay.
A.
So we'll call a roll.
Councilmember Gallegos.
Yes.
Councilmember Rodriguez.
Yes.
Councilmember Montes.
Yes.
Mayor Pro Tem Evans.
No.
Councilmember Mejia.
No.
Councilmember Villegas.
No.
Mayor Garcia.
No.
Motion fails. 4 no votes, 3 yes votes.
Thank you very much. We will now move on to the consent calendar. Item B, matters listed under the consent calendar are considered routine and will be enacted by one motion and one vote. There will be no separate discussion of these items. If discussion is desired, a member of the public or a member of the council, I just want to say, Keith and Will, thank you very much for your report. I apologize because we didn't thank you for your taking the time to make your presentation. So thank you very much for your hard work.
Thank you, Mayor.
There will be no separate discussion of these items. If discussion is desired, a member of the public or a member of the council may request an item be removed from the consent calendar, and it will be considered separately. Alicia, do we have any members of the public wishing to speak on the consent calendar?
We have no written public comment, Mayor.
And no one on Zoom.
Thank you very much, Mark. I will now close public comment for this item. I will now ask for discussion and or a motion from my colleagues on the consent calendar.
Move to approve consent as presented.
I'll second.
Motion to approve the consent calendar by Councilmember Montes, second by Councilmember Rodriguez. All those in favor say aye.
Aye.
Any opposed? The ayes have it. Thank you very much. Under item C, public hearings. Item C1 is a public hearing regarding annexation of 13 track 21-502 and 51-503 TSM 2020-04 Vineyard Estates subdivision into Community Facilities District 2005-1 Public Services under the Melio Ruse Community Facilities Act of 1982 and related actions. This was actually pulled. Was this item pulled, Alicia?
Yes, is this going to be for Will or Gary to comment on?
Yes, I'll take that. Thank you, Alicia. Mayor Garcia, Mayor Pro Tem Evans, council members, this item was not properly noticed in compliance with the government code in that it was not published in a paper of circulation, i.e. the Tribune. That is a matter that staff has corrected. The notice has been delivered to the Tribune. It will publish this Saturday, and therefore staff is going to request that this item be continued to a date and time certain. That date and time being the regularly scheduled meeting of the council on November 16th.
Okay, thank you very much. We can just say yes to that request.
I would recommend you make a motion to continue it to November 16.
I make a motion that we continue this item to November 16th.
I second it.
Motion to have this item on November 16th. All those in favor say aye.
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 Any opposed? The ayes have it. Thank you very much. We now move on to item D, petitions, bids, resolutions, ordinances, and agreements. Item D1, amendment number 1, consultant services agreement between the city and QK Inc., presented by Will. Do you have this item, Will?
Yes, I do. Thank you, Mayor. Again, Mayor Pro Tem Evans, council member. This item is requesting an amendment number 1 to the existing consultant service agreement the planning department has with QK Inc. We are asking that the total compensation amount that's provided within that agreement not to exceed $50,000 be increased to $65,000. The intent is to supplement our remaining budget with additional funding from the Parks Department so that QK Inc. may assist both planning and parks in pursuit of a competitive grant for Tozier Park. That would allow us to provide additional amenities and reduce potential reimbursement costs and impact to the city's development impact fee funds. Again, this is a competitive grant. It is a National Park Service grant, so NEPA environmental review is required in addition to CEQA, and that's where we are seeking assistance from QK Inc. In addition, QK will be providing some of the grant writing assistance and park designs based upon the direction with staff for pursuit of that grant. So this will not require any additional monies from the general fund, just an allowance to reallocate existing funding from the Parks Department to the Planning Department. That can be facilitated by the city manager. We're asking the council to approve the amendment to increase the not to exceed compensation amount for the equivalent of what would be supplemented by parks funding, $50,000 to $65,000. Thank you.
Thank you very much, Will. Alicia, do we have any public comment regarding this item?
No written public comment, Mayor.
And no one on Zoom.
Thank you very much. Anyone here wishing to speak on this item? Thank you very much. I will now close public comment on this item, and I will bring it back for discussion and or comments from my colleagues. This time I see none. I will ask for a motion regarding item D1.
So moved to approve D1 as presented.
Second.
Motion to approve item D1 by Councilwoman Gallegos, second by Councilmember Villegas. All those in favor say aye.
Aye.
Are any opposed? Say nay. The ayes have it. Motion passes. Thank you, Will. We will now move on to item D3, actions related to reimbursement to developer for Almond Park improvements. I believe, Mr. Helmuth, you have this item?
That's correct. Thank you, Mayor, council members. Yes, this item is with regard to.
Okay, hold on a second. I think we're on item D2. I skipped item D2. I'm sorry, Keith. We will go back to item D2, utilization of three-party agreements for professional environmental consultation services by Will. Do you have this item, Will?
Yes, I do. Thank you, Mayor, Mayor Pro Tem, council members. This item is requesting the council adopt a resolution authorizing staff to facilitate a program for use of three-party agreements with consultants and our applicants for environmental consultation services. At present, well, as we all know, environmental analysis is a mandatory and integral part of our entitlement and application processing, and based upon the state and or federal regulations that are associated with that, can have a major or can majorly dictate the timing of our processing. What a three-party agreement would allow us to do would actually allow the developer or applicant to select a consultant subject to staff approval, the scope of work to be prepared by that consultant for purposes of the project would also be subject to staff approval. But what it allows the applicant to do is make a preferred choice of their consultant and independently negotiate based upon market circumstances an agreement for cost of preparation of those services. The advantage to that, while again, it would be dictated by market costs, they're the same services that would otherwise be provided through on-call contracts, but it would allow, again, some selection and the ability to control destiny by an applicant, i.e. if they want to pay more to go faster, it gives them the ability to do that. It also would give the opportunity to engage early. I've seen these three-party agreements utilized in circumstance where we can engage early with an applicant, even at the pre-application stage and prior to formal application acceptance or completion, where they can start work on their environmental documentation. It will require supplemental information resultant from the distribution for comments. That's part of the process. But again, we can engage early. And in some instances, we can have an initial study prepared for the most part before an application is even deemed complete. And that means less time devoted to that application or on the back end following application acceptance. So again, asking for authorization to come up with a program for use of these three-party agreements. Staff has been in consult with the city attorney and would continue to consult with the city attorney to come up with a three-party agreement which protects the city from liability and would allow such agreements to be executed easily and expeditiously. And so that's the request for the evening, is to adopt a resolution that would authorize staff to move forward in this manner. Thank you.
Thank you. Very well done. Alicia, are there any members of the public wishing to speak on item D2?
No written public comment, Mayor.
And no one on Zoom.
Thank you, Mark. I will now close public comment and we'll bring it back to my colleagues for either questions or discussions or a motion.
I motion to approve D2 as written.
Second.
There's a motion on the floor to approve item D2 by Mayor Pro Tem Evans, second by Councilmember Villegas. All those in favor say aye.
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 Any opposed? Motion passes. Thank you very much, Will. Keith, we'll come back to you. Under item D3, actions related to reimbursement to developer for Almond Park improvements.
Thank you again, Mayor. The purpose of this particular meeting is to consider a resolution approving reimbursement to Joseph Crown Construction Development for construction of Almond Park improvements. The Almond Park is located in the subdivision to the southwest corner of Almond and Stadium, also shown as 26.5 in this particular drawing. It's about a little over 1 acre parcel, as you see outlined in red here. The park experienced its grand opening on August 15th at 6 p.m. of this year. That's just the invitation to the grand opening. A little bit of background with regard to this. The Joseph Crown, I'll refer to him as Crown or Crown Development in the future, constructed park improvements at the Almond Park. The park was accepted May 4th of this year. Subsequent to acceptance, it was determined that no provisions, including the conditions of approval or the agreements associated with the project, were made that officially required the park or allowed for reimbursement of the improvements associated with it. Without reimbursement provisions, staff could not consider reimbursement without council authorization. Likewise, council could not consider reimbursement without a request and associated justification. As such, Crown Development submitted a request for reimbursement in the form of a demand payment. The typical process for reimbursements, it follows along with the entitlement process. There's a tentative subdivision map approved by the Planning Commission. That tentative map contains conditions of approval that ask for specific items be included with the project. One of those items would have been the park improvements. That condition would normally be within those conditions of approval. The final map was ultimately approved by City Council. If the condition was contained in the conditions of approval and eligible for reimbursement, the improvement agreement would have included the provision for reimbursement. It's staff's opinion that Crown Development did construct the park at the behest of the city staff, regardless of the Planning Commission and the council record. Crown Development's demand is based upon the understanding he had with staff that the park was required, based upon multiple conversations that he had with staff and multiple emails discussing the plan reviews at the park and what amenities should be included. I've seen multiple emails associated with that. I didn't participate, can't recall participating in any of those except for towards the last few months or so, but I am aware of them occurring. Based on the review of staff, Crown Development could reasonably be assumed to have understood that construction of the park was indeed part of the subdivision's approval. The recommended action is to adopt a resolution approving reimbursement to Joseph Crown Construction and Development for Almond Park improvements. With that, I'd be happy to take any questions with regard to this item.
Thank you, Keith. Alicia, do we have any members of the public wishing to speak on this item?
No written public comment.
And no one on Zoom.
Thank you, Mark. Anyone here present wishing to speak on this item? Hilda, would you like to say something?
I just wanted to underscore, it's in the report, but that this was something that happened, and staff will be correcting this by including the requirements in the conditions of approval in the future. And there are a number of other items where it has not actually gone to full fruition as far as the construction, but where the conditions of approval were not expressed. And so the improvement agreements are going to come before you in the near future on those items.
Okay. If there's no further public comment, I will close public comment and bring it back to my colleagues for questions and or discussion. Councilwoman Gallegos.
Thank you, Mayor Garcia. I don't know if this question's for Kingsley. Once it's approved by council tonight, how long will it be to be able to issue that payment to Joseph Crown, since it's been built for a while?
Council member, Mr. Mayor, council members, I think once it's approved tonight, if it's an urgency, we can cut an emergency check. But otherwise, it will go through the normal accounts payable process. And by next week, it should get out.
Okay, thank you.
Seeing no further comments, I will ask my colleagues for a motion on item D3.
I motion to approve D3 as presented.
Second that.
Motion to approve item D3 by Councilwoman Gallegos, second by Councilmember Montes. All those in favor say aye.
Aye.
Any opposed? Motion passes. Thank you very much. Thank you very much, Keith.
Thank you.
We will now move on to item E, administrative reports. Item E1 is a Parks and Community Services Department fiscal year 2022-2023 planned improvement project. I believe Mr. Hebert, are you here for this?
Yes, I am, Mr. Mayor. Thank you for having me, Mr. Mayor, Mayor Pro Tem Evans, and Council. Can you see my screen okay?
Yes, sir.
Okay, so this is a Parks and Community Services Plan Improvement Project. It's an informational presentation. We were requested the last council meeting to discuss our status on the Sunrise Rotary Sports Complex playground equipment that's to be installed. We made a decision to give an overview of all the projects that we have in addition to the Rotary Sunrise project, just to get ahead of questions that might come up in future meetings. We have several improvement projects in our sites, and we're trying to do that and all the time, and at the same time maintaining our day-to-day services to the community. The following projects are presented in no particular order, but I have indicated where the funding sources have come from. The first one up is the Lionstown and Country Park Restroom Project. This project is ongoing. We expect to have a bid release at sometime at the end of November on this. The next project is the James Talbert Park project, which was previously named the Olive Park, and where the funding source for this is a $2 million grant. The following project is the Fresno River and Vernon McCullough River Trail project, which is from our Clean California grant, which was approximately $832,000. This project is ongoing. We've already done some litter abatement. We've got some other plans to work. We're working through the procurement process to secure some exercise equipment, and we're planning on working with MUSD as far as rehabbing some trash receptacles, and we're also going to be planning on resurfacing the trail in those areas. The next project is a Rotary Park asphalt curb replacement. This project has been ongoing. We're actually working with procurement, legal, and public works to try to find a way to best complete this, and also staying cognizant of the procurement rules. We think we might have a path forward within the next week. We're trying to piggyback on an existing contract, and so hopefully we'll have a resolution within the next week. The next project is actually the Lionstown and Country Sunken Concrete Project, and this is on the south west corner of Lionstown and Country. And actually, I keep calling it a sinkhole, but basically, this project, we have a degradation in the surface on that corner, and it's causing impacts to our concrete there, and also to some of the fencing. We've already started work on this as far as getting reviews on the soil. We're looking at, we contracted with a firm, a technical engineering firm, and they're going to, I guess, do some preparation as far as looking at the compacted subgrade on this. And they should have a report within, I guess, the next week or two for us, so we can figure out the next steps as far as getting this accomplished. The next project is the India Park site demolition project. This is coming from development impact fees. The budget on this is $92,000. An award was made to MAG Engineering for the demolition services, and the project is scheduled to be completed by the end of December of this year. This was the one that actually was the catalyst for this presentation. This involves the Sunrise Rotary Sports Complex playground equipment installation. The source of the fundings will be $40,000 from the general fund, $15,000 from a Chachansey grant. This was actually awarded back in 2016, and the equipment has been sitting in our yard since that time. We ran into some issues as far as the procurement process on this. We're trying to follow formal procurement processes, but the thing is, we don't know how much of the equipment has been degraded because of weather and how much is missing. So trying to figure out actually a formal procurement process without really knowing what we're dealing with, we had to step back and do this in 2 phases. So the first phase will be to contract with someone to figure out exactly what we're missing and what we need. The next phase, once we determine that, will be a formal solicitation. And this is all trying to stay within the budget amount of that we have designated for this. The next project that we have, and this one is actually pretty much complete, and this is the plaque for Tadea Saran. We'll be doing this at Centennial Park. The funding source for this was $3,000 of donation and then $17,000 from the general fund. We already have this planned, tentatively planned to have a dedication on the 3rd of December for this. And actually this came in under budget, where we actually saved about $4,700. The next project on this is another plaque, and this is for the Ripito family at Rotary Park. This we'll have a ceremony scheduled for this on the 9th of November. And again, this is another project that came in under budget. We had budgeted $20,000 from the general fund, but the actual cost came in about right around $12,000 with an $8,000 savings. The next project that we're working on is the McNally improvements, which we received $609,000 through the CBDG grant. We haven't started on this one yet, but we'll have to go through the same process that we did for the James Talbert Park. We're probably going to have to procure contract with a design engineering firm to get that started. This one actually, I think in your packet, it says we're still pending the looking for the check. This is a grant awarded by Dick's Sporting Goods Foundation. We actually got the check today. So to get ahead of this, we had kind of started the procurement process in anticipation that the check would arrive. We're waiting for one more bid, and I think we should be able to get started on this. And I anticipate this project coming in under budget as well. The next is just the Lionstown and Country Park rehabilitation. I've kind of talked about some of the things that we've accomplished already at Lionstown and Country, but this is, again, $75,000 from the general fund. Also out of this, the $25,000 that I talked about earlier about the sinkhole is related to the improvements there. And this involves, you can see water fountains, we have some cracked cement, but these are some of the improvements that we're doing there. Painting of the bridges, and so it's all coming out of this bucket of money. Some of the ongoing and completed projects that we've done some pool repairs. We've had a leak. We fixed the scoreboard at the John Wells Center. I think I talked about earlier in another council meeting that we've got a machine to help with gopher eradication, which is actually working very well. Don't get nearly as many calls as I used to get when I started about gophers in Town and Country Park. Some of the other deferred maintenance that's happened continuously, and that's with John Wells Center, Frank Burgon, and Pan Am, is to make those all usable. And that's the end of my presentation. Thank you so much.
Thank you, Joseph. Thank you. Really good. Alicia, do we have any public comment regarding item E1?
We have no written public comment, Mayor.
And no one on Zoom.
Thank you. I'll bring it back to my colleagues for any comments or questions for Joseph regarding the parks.
Thank you, Joseph.
I do. If no one else will. Thank you very much for that report. I know that Parks and Recreation has been long issues that we've had for years and years. Just for example, that 2016 project that you're talking about, it's disappointing that we've had some equipment that was bought, donated, and that has deteriorated. But if we could move forward in a positive way and make some corrections to some of these issues, I think we'll go a long way toward making our city a better place for our children and our grown-ups to be able to go out and enjoy the parks and recreational facilities that we do have. I do have one comment. That one drinking fountain, there's actually two of them that have been in the city. I don't know who built those things or designed those things, but they're got to be the ugliest drinking fountains I have ever seen. They look like pieces of cast iron or something that were planted out there, and they put a couple of pipes for water. So I'm glad to see those go. Who was first? Because I don't remember seeing. Mayor Pro Tem Evans? Yes, go for it.
Thank you, Joseph, so much for all this, for all the work that you're doing. And thank you for just taking care of the parks. It's so good to see the work that's going in at Town and Country. I utilize that park quite often, and this is just a real plus. As far as the restrooms, thank you for those as well. They're in desperate need. Also, as far as the water faucets are concerned, I too agree with you, Mr. Mayor. The water faucets are just the one that you guys put in at McNally. It's just adorable. That's the best way I can describe it. The puppy loves it and all that. So I'm waiting to see all the other things that are going to be happening there. And everything's coming together. You're just doing an outstanding job there, Joseph. Thank you very much.
Okay.
I passed the baton.
Okay. Councilwoman Gallegos.
Thank you, Mayor. I just wanted to make a comment really fast. It was on my council reports, Joseph, was to talk about the river and the trail. I've had a lot of residents are using this more now that we've cleaned up the river and the homeless are not there. They feel safe enough now to walk that trail. And so exercise equipment would be great. Also, we had some benches that were made out of like railroad ties that kind of probably need to be resealed. If we can kind of just give some love and care to that out there, because we do have a lot of residents taking that because we've had some great weather other than this rain that we've been blessed with today. So with that, thank you, Mayor.
Councilmember Mejia.
You skipped me. But thank you very much for the report, for the all of the updates. Like I had mentioned during the last meeting, it was concerning to me about this playground structure. And I'm disappointed that it has been sitting there for years. As it is, we already have very limited opportunities for our young kids to play. So just hoping that that will be resolved as soon as possible. And thank you very much.
Councilmember Villegas.
Yes, thank you, Mayor Garcia. Thank you, Joseph, for the report. I think we need a lot of improvements in the park, so that's good, you know. Thank you for that report. That's it.
Well, I guess you met with the council's approval, Joseph. Thank you very much.
Yeah, thank you.
If I can just add a couple of more things, and that
Arnoldo.
As Joseph was talking, I started thinking about him. On top of everything Joseph said tonight, we obviously have a lot going on. Not only that, the other thing that we've been doing, and I'm saying we, it's Joseph and his team, not me. They've really been doing a lot of addition by subtraction. They've been simply removing things that are broken. We've been painting a lot of different items that I think the community is really recognizing. The other thing we've done is we've been very aggressive with our tree trimming program. We've been trying to eliminate dead trees, and we're also trying to make sure that no more trees die. On top of that, there's a couple of other projects that are on the horizon that are in Joseph's wheelhouse. We have another park that's going to be built by a developer, but it would be paid for through development impact fees at Pecan Square, which is on the southwest corner of Avenue 13 and Pecan. That's part of the new subdivision that's being constructed as we speak. We have another park that we talked about. It was earlier today that Will had mentioned on Tozier Park. That park is also going to be paid through development impact fees. However, what we're attempting to do is we're attempting to double the amount of money via a grant. If the city's not successful in getting the grant, because again, it's competitive, the park would still be built. And then we also have another park that's going to be built by KB Homes over in Northwest Madera off of Cleveland, and that's going to be paid for by development impact fees. The reason I say that is on top of everything you have on your screen or that Joseph talked about, we also have 3 new parks that are going to be built. We just completed Almond Park. There's a lot of on our table. And as Joseph, he's very humble, him and his team, but I'm constantly encouraging them to try to go after more grant dollars. And I know Joseph is probably thinking, I can't even spend all the money we have right now because we have been very successful. But and that's to brag a little bit about our team, that there's a lot in the pipeline. And Joe and his team and the rest of the team, Keith, they deserve a tremendous amount of credit for all the balls that are in the air right now. And there's a lot there. Thank you.
Yeah, you're right. Yeah, you're right. Councilmember Villegas, did you just have something to add?
No, turn it off.
Already? Okay. All right. Well, thank you very much, sir, for your report. We will now move on to item E2, appointment of council members for the PG&E working group. This presentation is by you, Mr. Rodriguez.
Yes, thank you very much, Mayor. Allow me to pull up a presentation here. As council is aware, we've had some challenges here in the city with PG&E providing adequate power or sufficient power to new development. So this is not necessarily an issue of existing development. There's adequate power for existing development and existing residences. This is for new construction. I understand that Fresno's been on the news the last couple of days regarding power. I can't speak to their issues. I can only speak to about the city of Madera, and ours may be somewhat they're a little bit different. I believe in Fresno's again without really knowing exactly what they're going through. But in a nutshell, the city of Madera is served by 3 substations around the city. Those 3 substations are near maximum capacity in terms of their energy output. The challenge that's created for the city is whenever we have a new development, we then have to go meet with PG&E, and these are not 1-hour meetings. Sometimes these meetings will go on for months about, does PG&E have adequate power to energize either industrial development, homes, water wells. The biggest challenge we've had as of late has been industrial users. To be candid, the city has lost on industrial opportunities. There has been industrial development that said, thank you very much. We like Madera. We like what you have to offer, but we can't hold off and we can't wait any longer. We had to be in operation yesterday, so they've gone to other cities. To PG&E's credit, though, they in certain cases they have worked with potential tenants and they find alternatives somehow. I don't always know what those alternatives are because I'm not an electrical engineer and some of it's out of my expertise. So one goal is in working with PG&E is to establish a working group to try to determine some potential solutions and try to work in partnership with PG&E to say, we know we have an issue, but we can't stand on the sidelines. We have to be more aggressive and we need some answers, because one of the challenges that we're having, again, every time a new development comes into town, one of the biggest things or one of the first questions I'll ask is, have you talked to PG&E? Do we have adequate power? And so we have actively been engaging with some potential members of this working group. And so far today, these are the individuals that have committed to serving on the working group. We have the EDC, we have the Chamber of Commerce, Madera Unified School District. They're in the infant stages of designing a brand new school, a K-8 school that's going to serve up to 1,000 students. And that's a lot of students. We would want to make sure that they have adequate power. We know Madera Community College is being very aggressive in developing. We have Almond World, which is under construction right now, 250,000 square foot building. They'd like to develop a second 250,000 square foot building. The only reason they haven't broken ground is lack of power. Span Construction, which is at the heart of a lot of these projects because they own a lot of property, or they're the contractors or developers, and a lot of their projects aren't put on hold. We have MID board member and local grower Dave LaQuashi. Dave had approached me some time back and said, I need a water well, but PG&E's telling me I don't have water. This is outside of the city. So I said, okay, well, let me sign you up. We have Planning Commission Chairman for the city, Bobby Grant. We have DMP Homes owner, Mike Pistresi, Landmark Realty, Ed McIntyre, Senator Ana Caballero or her office will be at the meeting. I'm not too sure if the senator will be able to make it herself. And then we also have County Supervisor Robert Poitras. So with that, rather than city staff attempting to identify which council members would best serve, I thought the item would be appropriate to bring it before council. Up to 3 council members can serve. And the reason the 3 is going back to Hilda's presentation earlier today, you cannot have 4. It's a violation of the Brown Act. And so the first meeting is scheduled for November the 18th at 10 a.m. And again, this would be the initial meeting as a working group. I understand a lot of us have probably individually met with PG&E. I know a lot of the folks on this list have individually met with PG&E, but I thought it'd be appropriate for all of us to get in the same room and try to identify a path forward. And that's the goal here. So with that, Mayor, I'll turn it back over to you and the council.
Thank you very much, Arnoldo. I do have one question, Hilda, regarding appointment of ad hoc committee members. Does the public have any input on this? You still need to bring it back.
Yes.
Okay. Thank you very much for that. Just for clarification. Alicia, do we have any members of the public wishing to comment on item E2?
We have no written public comment, Mayor.
And no one on Zoom.
Thank you very much, Mark. We will now close public comment on item E2 and bring it back to council for comments and action. Councilmember Montes.
So this has been an issue that has been going on. People have been reaching out. I know everybody has had somebody reach out, but I know that Councilmember Gallegos has been at the front of a lot of this, and I would recommend or nominate for her to be on the ad hoc. I believe Councilmember Rodriguez as well has had some contact, so I would make the recommendation to have council or not in the nomination for Councilmember Rodriguez and Gallegos to be on that if they have. I know they're on a bunch of boards, commissions, if they have capacity to do so. And maybe might add Councilmember Mejia if she's available to do so to kind of get, I don't know, I don't want to say learn the ropes, but with some more senior council members kind of be part of that process. So that would be my nomination for those 3 council members to be on there if they would accept.
Accept.
Do all 3 members accept?
I would accept.
I accept.
All 3. Okay. Is there any more nominations? Seeing none, is there a motion and a second?
So that's my motion.
And a second?
I'll second the motion.
Motion to appoint council members Gallegos, Rodriguez, and Mejia to the ad hoc committee for PG&E. All those in favor say aye.
Aye.
Any opposed? Motion passes.
Okay, Mayor, before adjourning the meeting, we're moving to the next item. Also, if the council or anyone in the community that's watching has an interest on joining us, or if they know of someone that would want to join us, just have them reach out. This is not, we don't have a limited number of seats, but again, the goal is to establish a working group of people that have a vested interest, which is obviously a lot of people potentially. We simply want to make sure that we have a well-rounded group that represents a diversity of people, and it's not necessarily one-sided. So again, it's not, there's no application. This is simply people that have reached out to me in the past. So again, if the council's aware of someone, we would welcome them. However, they have to buy lunch.
Yeah, great. Now, do you know if the meetings will be regularly at 10 o'clock in the morning?
No, we have not established a specific dates or times as of right now. However, the first meeting appeared to work for most people that I spoke with, which was really PG&E. They said that November the 18th at 10 a.m. worked. So we reserved a 2-hour slot. I think it would be appropriate for the working group, once the working group starts meeting, for the group to collectively identify time and date. And so then it's not necessarily city staff doing it, but rather it's a unified front or unified unit.
Thank you.
Mayor, if I may. I know you brought up a good point. I'm not sure.
Councilmember Rodriguez.
Sorry, I'm not sure how many of these series of meetings we're going to have. And I don't know if it'd be appropriate at this time also to maybe select an alternate in case, you know, these meetings are prolonged. I don't know. And one of the members cannot attend. I'm not sure if that's something this. Okay. So what I mean is, assuming that one is absent, you can't have someone go in there. Okay. Just as an ad hoc, you got to stay within that group. Okay. Good. And did you answer that question regarding the meetings? We don't know what this, how many meetings we're looking at.
No, unfortunately, I think it would be premature. I'm not too sure if we're looking at 3 meetings or if we're looking at 5 meetings.
Okay.
I can state that last November, I was informed that PG&E would have solutions in 24 months. We're technically a year into it. So 12 months from now, I'm going to speculate and assume that the situation would be resolved, but I can't state that with confidence.
Great. Thank you. Thank you, Hilda, for clarifying.
I have one more question. So I know this is a working group, and we want to have kind of like a unified direction, but there's nothing prohibiting the rest of the council from talking to PG&E themselves or other people, or is that something that, I mean, I know strategically it might not be the best thing. We just can't discuss it amongst ourselves or each other. So you won't have more than a quorum because, I mean, I know people from PG&E and I give them the stink eye every time I get like, hey, what's going on, you know, with this issue. But just, I'm not going to be part of the group and I'm not going to know what the group is talking about unless the council brings it back in open session and discusses for updates. Correct?
I would be, yeah, if you're just talking to PG&E directly, but if you start talking to a majority of the members of the working group, not that they're subject to the Brown Act, but I would be careful.
No, because I mean, PG&E reps and people reach out to us all the time, right? So, you know, we can give our opinion on the matter. So we don't want to overstep our bounds or give a different direction than what the working group is doing. And then we'll have that information on the periodic updates, I'm assuming.
Yes.
Right. All right. Yes.
Thank you. We will now move on to item F, council member reports, announcements, future agenda items. This portion of the meeting is reserved for the mayor and the council members to make brief reports on boards, committees, and other public agencies and at public events, to request updates, to initiate future agenda items, and to take action on matters initiated under this section of the agenda. Under this section, the council may take action only on items specifically agendized and which meet other requirements for action. Councilmember Gallegos.
Thank you, Mayor. I just wanted to do a shout out to Chief Lawson. Lawson that's not here. We sure miss seeing him in the audience with the rest of the folks out here. The first thing I want to do is to give a shout out to Joseph, Joseph in parks. Not only is he rocking it with the parks, he's also rocking it with the rec part of it. We have a lot of programs going out to our community youth and adults. So I thank him for having that all out there for them. The last thing is next week is Veterans Day. So I would like to salute all those vets out there and all those armed forces that have protected us throughout the years. So thank you for your services, Mr. Montes.
I did want to say thank you to the community for all the events that one of the trunk or treat stuff that went on. I wanted to attend all of them, but I couldn't, and it's probably good for my waistline that I didn't. I did get to attend one event yesterday, and I'm pretty sure Councilmember Mejia is going to speak about this, but I do want to thank Rosa, Sylvia, Jose, Joanna, Noe, Abraham, and Councilmember Mejia for everything they did to put on the event of the Dia de los Muertos yesterday at Courthouse Park. It was a really fun event. I was kind of sad because it started raining and I was like, hey, you know, the altar is going to get wet. but there were still a lot of people out there. They put a cover over it, and it was a really fun event, really good food. So I really enjoyed it. I also wanted to, some of the stuff that we talked about earlier regarding the rolled curb. We talked about some issues that don't necessarily go or can be parted out from the rolled curb. So maybe bringing back an item for the front yard standards, so that people don't put cement for their whole front yard. And that's something that this council can still consider apart from, because I know that was something that we wanted to avoid. And if that's something that the council would consider to bring back at a future date, for staff to at least bring something forward regarding that item.
You're looking for thumbs up.
Thumbs up. Yeah.
Yeah, I don't think anybody would have a problem with that. I think that would be a good item. So we will go to Mr. Rodriguez. I think you were next.
Yeah, we might as well bring back the rolled curb.
I think we'd be down to death.
I think we've already. Yeah, I just want to say thank you all. 6 days to the midterm elections. If anybody's watching out there, there's a lot of good initiatives, a lot of good stuff out there. I encourage every one of you to go out and vote. The turnout typically on these midterm elections is pretty low. So if you know of anyone that still hasn't voted, there's still time. People always say this is what you get, but a lot of times it's because we don't vote. So get the word out. Other than that, yeah, have a good night.
Mayor Pro Tem Evans.
Yes, I would like to thank the Juvenile Probation Department for contacting us, and to be told that I called and I said that, is it okay if we bring some candy? And they said, sure. And my comment back was, okay, we'll see you at 10 minutes to 5. And they said, oh no, the city of Madera has a booth. So consequently, I contacted our city manager, and he was just bubbling and wanted to know what should we do. So he got the canopy, the table, and the chairs. Alicia took care of the candy, and I went around and gathered up things, and we created a beautiful booth for the city of Madera. So that was kind of cool. We did it in 45 minutes? Yeah. Literally, from the time we got the information till the time we got everything completed, it was 45 minutes. So woohoo for us here at the city. Also, I did a crunch with the councilwoman with James Monroe and the students there. I had 10 young people, and they were really quite interesting. They wanted to know about becoming part of the city management. So, and although you have some people looking for jobs, so, open up the doors and let them come on in. I also judged the Halloween contest at the Madera Community Hospital. And one young lady, she's been with the hospital for 56 years. Her name is Iola, and she won. So those are some of the things. And thank you, staff. Thank you, everyone here on council. Be careful out there in the rain, and God bless each and every one of you. And I hand the baton back, sir.
Okay. Councilmember Mejia.
We had a great Dia de los Muertos event yesterday. As Councilmember Montes mentioned, the rain didn't stop it. Very beautiful celebration that truly was driven by the community. We had the opportunity to learn how to make papel picado. We had workshops for that, and then how to make bread, Day of the Dead bread. So thank you, Councilmember Montes and the Elks Lodge for providing the space. Also a shout out to County Supervisor Leticia Gonzalez for her support of the event. It was very beautiful, and I think the whole community enjoyed it. I couldn't make the presentation, but I would just like to say thank you to Senator Caballero for the $5 million for the infrastructure of Madera. So thank you very much. We know we really needed it and appreciate your support.
Councilmember Villegas.
Oh, nothing to report.
So as far as my report, I want to thank Madera Community College President Angel Reina for inviting me to the President's State of the College breakfast at Madera here in Madera. It was well attended, and he gave an overview of what they've done and are doing at the Madera Community College, which is amazing. So props to him and his staff for getting the work done out there. Also, we were able to attend today a presentation and press conference by Sheriff Pogue, Madera County Sheriff Pogue, Tyson Pogue, where they presented that there was an intergovernmental task force that arrested 29 or I believe 28 suspects for trafficking methamphetamine in Madera County. It was the largest drug bust in the history of Madera County. And glad to say that the Madera Police Department was just one of the agencies that was a part of that. And so very proud of the fact that we put criminals away and that we have confiscated and heroin and methamphetamine, et cetera, in the county of Madera. So kudos to them and all of those that were part of that. So other than that, I'm just going to go ahead and close out the meeting. There is no closed session meeting tonight. We're going to be calling for adjournment. It is now 9:20 in the evening, and this meeting is adjourned. And I want to thank everyone for participating. Our upcoming meeting dates are Wednesday, November 16th of this year, and Wednesday, December 7th of this year. Thank you very much, and have a good evening.
And thank you, Hilda, for hanging in there, not feeling too good.